Unmuted. All right. And they'll grab you here in just a second. You're unmuted, so talking, you're gonna be talking. Well, I hope it works. We'll know where in the few. If it don't work, we'll get her something else taken care of. Yeah, let's go again. Yep. Work. Come on. Yeah, your speaker's good now, so we're all good. Good. Yeah, thank you. So as soon as they kick on, they'll pull up and they'll say you, because they already say you're in. What? No, it's just not. It's just like they're like their mouth when you watch. Cut you off. Oh, they just cut you off because they're handling. Here in a minute, they'll call for you. Oh, so yeah, the judge has different things he can cut off, so he's cut yours.
Can you hear me at the Dixon County Jail?
Hello.
Turn your volume up.
Can you hear me now?
I was getting ready to say the
Why do I
exact
feel like
same
I'm in
thing.
a commercial? I can hear you. I don't know if you can hear me. Can we send a message to them to let them know that we are able to hear them, but they're not able to hear us? While they're working on that, let's go to the Perry County Jail. At the Perry County Jail, can you hear me?
Judge.
Here, hold on. Speaker not working.
Unplugged it, plugged it back in.
Try one more time.
We can hear you at the Dixon County Jail, so watch what you say.
Okay, you should be able to hear us now.
Can you hear me, sir?
I can hear you. Can you hear me?
Yes, sir.
There we go.
Thank you.
Great. Go ahead and tell me, what is your name, please?
Thomas Lane.
All right, Mr. Lane, he is on page 10. Mr. Flanagan is your attorney. And Mr. Flanagan is running late. Your case is set for status today, and if Mr. Flanagan wants to have you brought back or have you transported, then we will do that. But right now, what we're going to do today should be the final plea day. Have you had any discussions with Mr. Flanagan to know what the status is?
I believe he was trying to. I haven't heard anything else.
Right. In any event, Mr. Lane, if your lawyer does not have something, resolution, we're going to set you for trial the next term of court that I'm here. So, Mr. Flanagan will be in touch with you to let you know what the status is.
Okay, thank you very much, sir.
Yeah. Morning. Are you Thomas Warden? I'm sorry.
James.
Are you James Warden?
Yes, sir.
Warden is represented by Mr.
He's
Flanagan as
also
well.
represented by Mr. Flanagan.
Your lawyer, Mr. Flanagan, is at another court, but he is coming later in the day. You are here today to be arraigned on a second superseding indictment. We will give a copy of that to Mr. Flanagan, and if he needs to have you brought back on the Zoom link, we'll bring you back. But right now, that's where you are. You're here today to be arraigned on that charge. We'll give a copy of it to Mr. Flanagan and see what he wants to do with your case. All right, thank you.
Thank you.
Is that all you have there at the Dixon County Jail?
Yes, sir, two. That was all we had.
All right, thank you.
Thank you.
Let's go to the Perry County Jail. We have a Perry County. Are you Brandon Williams at the Perry County Jail? I don't think you can hear me. Can you hear me, Mr. Williams? Do you represent Mr.
I
Williams?
represent Mr. Williams, and we file a motion to continue. The state doesn't oppose to reset it the next time. One issue is a police officer to overseas deployed.
The detective that prosecuted the case is been deployed to the National Guard and will be back until I believe the end of March.
Right, so both sides agree that a material witness is not available due to his service in the National Guard, and he'll be back in it. When do we want to reset it then?
But your terms,
How many days? We'll make that motion.
I would say,
Judge, if it's a 2-day trial, if I've got your calendar correct, that would be required to be set on the 25th. If I'm reading your calendar correct, that's the only 2-day back-to-back you have. I may be mistaken.
January 25th on the points.
Well, I show I've got a criminal bench trial term no, I'm sorry, I've got a criminal trial on the 25th, and then do I show that there's a Turnbull versus Moore?
It's a 2-day bench trial. Yes, I had marked off that criminal day for the 26th, but I also have you 18, 19, and 20 for criminal days.
Well, the 19th is a federal holiday, or it's a state holiday as well, I think. So we
So would you
can,
not have the 25th and 26th?
well, the 26th is you have the 25th. The 26th, we had set a 2-day bench trial in a civil matter. If you want to start this on the 25th and it bumps the civil trial, so be it. The criminal trial will take precedence.
thank you, Judge.
25th.
25th of June.
Judge, what's the
This is the last plea day. So if he doesn't plead today, he will go to trial or plead to the indictment and all. So that's what the whole purpose of the final plea day is. Is there any reason to think there's going to be any resolution, General?
Well, we're working on a global settlement because he's got a Dixon charge. Reason why I asked for that, I've been working with the Perry County District Attorney on this case, and I think they're working with.
I'll give you the 17th of June, but that is the last plea day. If he doesn't plead on that, he'll go to trial or plead to the indictment.
Thank you, Judge.
All right. Mr. Williams, did you hear what was going on? We need to just send a message to Mr. Williams that you let your client know what's the status is. We're going to take him off the Zoom link. So.
What is his first name?
Brandon.
Brandon.
All right. Then let's go to the Humphreys County Jail.
Yes, Your Honor, we have William Scott Burns on page 3 of the docket.
Judge,
William Scott Burns is represented by Mr. Locker.
He is, Your Honor, and Mr. Locker's in another, sorry, he's in another court this morning. He was asking the court to reset this. I believe, isn't that what he said in the text message?
yes, this is set for status, and he's filed a motion to find the defendant incompetent and unable to stand trial. He needs a hearing date for that motion, as well.
25th of February.
Yes, sir.
Preston Dwayne
Yeah.
Carter, page 3 of the docket.
We have, is Terrence Rand.
Your Honor, Mr. Rand contacted me and said that he's in a trial right now. He just wanted me to get the trial date and the plea date for us.
Well, this is his plea date. So we'll give you a trial date. So.
Mr. Carter, just arraigned.
Well, this is the status.
He was just arraigned in
Oh,
December.
okay. All right.
But Judge, and so in juvenile, Mr. Carter is also being, excuse me, not also being, he has also been charged in juvenile court. And Mr. Rand has filed, well, I don't know if he's filed it yet.
He did file it last week, yes, sir.
Filed a motion to,
Order
to get him evaluated. So I don't know how you want to handle it.
All right. Well, what we need to do is just set it for status. And since this is a case that's on my docket, we'll keep it on that docket in
617.
617.
Malik Dunlap, page 5 of the docket.
Judge, Mr. Dunlap's represented by Mr. Brandon as well. He is a co-defendant of that Mr. Williams.
All right. So who are we dealing with?
Dunlap,
Okay.
page 5.
You set the other one for trial on the 25th, Judge, with the 17th plea date.
All right, set for trial on the 28th right now, but we're moving it to the June date, June 25th, June 25th. The last day of plea would be June 17th. Your lawyer's not here. He's in another court, but we'll let him know that we're setting a trial date in your case for June 25th. Thank you.
Ian Thomas Farrell, page 7 of the docket.
That's 13.
William Farrell, this is the new arraignment. Which he does have a couple more coming out of another grand jury. And he has some already set before.
We're going to give you a copy of that indictment, Mr. Cooper, and you wish a formal reading.
No, Your Honor, wait for reading, enter plea not guilty.
We're not guilty as entered. And this is the case, I've dealt with this case over and over
Yes,
and
sir.
over.
Your Honor, it was set before we redid the calendar in
Yes.
your April docket, so we will need to set it on your docket. And again, and I'm just making sure I'm reading it right. As you know, this is relatively old. This is not an old case, but the rest of it is relatively old. So it'll take, I think it's the most serious charge is a rape of a child. I would think it would take 2 days. He has been declared competent. So
Has he been now trained to be competent to stand trial?
They
said he was good to go.
All right. So Mr. Farrell was originally found to be incompetent to stand trial, but they believed that he could be trained to become competent. So now the minds at the Middle Tennessee Mental Health Center are saying he is competent and he can assist his attorney in preparation of a defense. So I know
That's
you're
what they
excited
say.
about that and that you're ready to go to trial, Mr. Hooper. So We just need to set it for trial. Is that correct? Now, here's the problem with this new schedule where you have a judge every month, is that in the old days, under the old schedule, we had a flex month, a month that was open that we could set these longer cases for trial. And
We don't have that.
we don't have that anymore. So,
Not gonna. Yes, and I'm able.
So Judge, if I'm looking correctly, October 23rd would be a Thursday, Friday, give us 2 days to try it.
you want to put it that far off? Well, he has new indictments coming in.
Here's a new indictment, and so what we're gonna ask is for leave to settle.
That, Ms. Stanford,
Oh, if
they
that
came back and said now that, one side is not available, and I told them they would have to come in and do a motion to set, so the schedule's back to the way it was.
great,
All right.
thank
So,
So we can give
have
Yeah.
two
you,
days available in October.
Yes,
Okay,
you. Is the LPA gonna stay on the 21st?
Yes.
Okay.
so if we could set it to 23rd, Judge, then I don't think we can set it in June because we don't have 2 days at this point, and that would give us leave, would give us leave to settle based on the charges and the new charges as well.
right, October 23rd.
Thank you, Judge.
Thank you, Your Honor.
Kevin Haas, page 7 of the docket.
Mr. Haas, you're here to be arraigned on a new indictment, charging you with aggravated assault. You have the right to an attorney. Do you wish to have a lawyer represent you?
No, sir.
You do not want a lawyer?
I need a public defender.
Well, they are lawyers, so. All right, we'll appoint a public defender.
Yes, sir.
Just terminology. The public defender probably has more trial experience than most private attorneys in criminal cases anyway. So you're lucky to have Mr. Hooper or Mr. Sensing, one of the two, that handle the public defender's office. But they are highly trained and highly efficient lawyers. So, Mr. Hooper, you wish a formal reading of the indictment.
No, Your Honor, and enter a plea of not guilty.
Plea of not guilty is entered from Mr. Haas. And are we setting
June 17th.
June 17th for status? Obviously, if the matter is resolved, you can get it in front of a judge before then for a plea if you wish.
Yes, sir. Thank you.
All right, thank you.
Thank you.
Jackson Hunley, page 9 of the docket.
Notice of appearance before Keaton has filed a notice of appearance for Mr. Hunley.
All right. Plea of not guilty is entered. We need to set it for status,
June 17th.
June 17th for status. Under our present rules that we're following, it is set for status. It's not assigned a trial date until after we determine that all discovery has been completed and all negotiations have been completed so that it's ready for trial. So we'll determine what your status is on June 17th, and if you need a trial date, we'll give you one then. Thank you.
Ryan Lancaster, page 10 of the docket.
One of those status, we got a new ring superseding environment.
Yes, Judge. So basically, the situation in that case is, you want to roll it to the VOPD or later than that? So basically what's going on is, he's got a home improvement contractor fraud. They're superseding the indictment to allege theft as well so that we can resolve it without any of the institutional infirmity that the statute has with the home improvement fraud. However, Mr.
I'm
Lancaster.
somewhat familiar with that particular statute, unfortunately, so meaning that I've had cases involving that before, and one which I mistakenly allowed them to convince me to do a bench trial in a criminal case such as that. I found the defendant guilty, and the Court of Criminal Appeals said I didn't know what I was doing, so they reversed it and vacated the judgment. So you don't count on me giving you a bench trial. Let's put it that way.
Well, Judge, you know, the legislature must be very smart to write such complicated laws.
I understand.
But
We have very, very sophisticated jurors down here that'll be glad to take care of it for you. All right, so what do you want to do with it? You want to put it on the status date for when?
Just for the BOP day, optimistically, we might be able to resolve it. He's got Dixon County case.
February the 28th.
Judge, he does need to be arraigned on the superseding.
Oh, yeah, we waive formal reading, enter plea not guilty.
Plea not guilty is entered. We're gonna set it for this coming February 28th.
25th, just on the VOP docket.
Oh, I'm looking at October, sorry.
We think we might resolve this case.
February 21st.
Thank you, Judge. I do.
Jeremy Jack Land, page 10 and 11 of the docket.
Thank you. I guess we're gonna need a trial date on those.
Charlie, you got a new arraignment.
We have a new arraignment.
Judge, on behalf of Mr. Lynn, we'd waive reading of the indictment, enter a plea of not guilty to all 7 counts.
All 7 counts. He is arraigned and shown to be represented by Mr. Baker. A plea of not guilty is entered. And Mr. Baker had indicated he wanted a trial date. Do you still wish to do that?
Well, it was on the other count. I think we've got status on a couple other cases, so we're here to get trial dates.
Right? Which one you want to try?
Judge, I can't remember which one we were gonna try last time. $14,094, Judge.
That is possession of Schedule 1 drug for sale, a Class B felony, possession of methamphetamine with intent, Class B felony, possession of drug paraphernalia. That's the one we're going to set for trial.
Correct.
Yes.
Right, that should be able to be done in a day, shouldn't it?
Yes, sir.
I think so.
So we put it on June the 18th.
June 18th. June 18th for trial.
You want to set a status date on this new indictment?
Well, that would be June 17th.
The rest of them will be June 17th.
Right.
For status. Thank you, Judge.
I was gonna make sure I was doing that right, but the 14877 is
Well,
the status.
Mr. Lynn, your lawyer's got you a trial date and a status date on the new arraignment, so he'll be in touch with you, get you ready for trial in June.
Michael Dean Marler, page 11 and 12 of the docket.
You want to hand your phone to the bailiff? Pardon? I said, did you want to hand your phone to the bailiff so she can turn it off for you? Just silence it for you. If it doesn't silence, go out and stomp on it and see what that has. All right, who do we have now?
This is
Michael
Mr.
Dean
Marler.
Marler.
He's on status
Right.
on 2 and an arraignment on page 12 on a new one.
We represent him on his current charges and be happy to accept appointment on the new one.
All right,
Waive formal reading of the indictment, enter a plea of not
clear
guilty.
not guilty is entered. And on the prior case, it is for status. So in view of the fact that there is now a second indictment, are you wanting another status date or do you want to set a trial date?
I think we would need a new status date.
Could we set this on the General McLeod has indicated to me we may have a conflict on the new indicted case. So could we set it for status on the 25th? And so I can look into that. And if we do,
June 25th.
Your office represents both.
well, our office is it's come to my attention that our office has represented both victims in the new indicted case.
And you think,
Stephanie Lowe went to General Sessions due to that conflict, if that helps.
All right.
We're happy to represent Mr. Marler on what we currently represent him on, but I guess he'd need different counsel.
oh, Mr. Waynick, can I appoint you on a case, please?
I wasn't paying attention, so you had
Michael Marler.
trying not to, please.
I know you were trying to be invisible in the courtroom, but it's a little hard for a man your size. So you are appointed to represent Mr. Michael Dean Marler, who is here on a new indictment charging him with aggravated burglary of a habitation, kidnapping, domestic assault, stalking, criminal trespass, harassment, joyriding, and driving on revoked license. And he is currently represented by the Public Defender's Office on a domestic assault and theft of property. Now, I can leave the Public Defender's Office in that case. We can let you represent him on all of those charges. It's up to you. If you feel like it would be better for you to represent him on everything, then I'm going to do that. He's indigent and therefore needs an attorney appointed. So
Let's do that. I think that typically works out better.
Mr. Sensing, you have a possessory interest in this criminal case.
Judge, I'm reluctant to let it go, but I think that
Right.
might be the most.
Mr. Marmer, I think it's in your best interest to have one lawyer who's working to represent you on all of your charges. So since the public defender has a conflict due to the fact they've represented the victims in this new indictment, I'm going to relieve the public defender and appoint Mr. Roger Waney. He is a member of the Dixon County Bar, but he's frequently in this courtroom. So he's familiar with everything that goes on down here, and he'll be able to talk with you and get you ready. Let's go ahead and put it on that June 17th for both cases. Status on both.
Your Honor, you represented me in the past, and I feel like it's a conflict of interest to have you as my judge.
I represented you?
Yes, sir.
It's been a while.
It's
Apparently.
been a while.
All right, let's move it to, well, I certainly don't have a problem with letting one of the other judges hear it. So let's put it on, you want to put it on April
the 15th, Judge.
April 15th.
Favorite day.
All right, that'll be for status. Mr. Wayne can nonetheless be appointed, but I agree with you. If I've represented you in the past, it would be inappropriate for me to stand as a trial judge in your case. All right.
Donald Matthews, page 12 and 13 of the docket.
Flanagan, Judge.
That's Mr. Flanagan.
Mr. Flanagan is your lawyer. He is in another court. He's coming, but he's coming late. So we'll determine whether or not he needs you brought over. And if so, we will have you brought over. So just bear with us, and Mr. Flanagan will let us know if he needs you brought over.
Michael McNear, page 13 of the docket.
Judge, I think we've got that resolved.
I'm sorry, who is it?
Michael McNear on page 13. It's for plea. We'll take it up now.
You need it brought over, are you able to do it, brother? Mr. McNear, can you hear me okay?
So,
I've been handed a document indicating that you're going to enter a plea of violation of the sex offender registry, a Class E felony, and receive a sentence of 2 years concurrent with Hardin County's violation of probation against you. And it would be, so is it 2 years to serve?
1 year to serve day for day, and then 2 years on probation, or another year on probation.
All right, so it's then suspended after serving 1 year?
It's running concurrent with Hardin County. You said that was what we were going to serve.
But it didn't say suspended, it just, form just says 2 years concurrent with Hardin County VOP after serving 1 year day for day. All right, Mr. McNear, raise your right hand, let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
yes, sir.
State your full name for the record.
Michael Ray McNear.
Mr. McNear, you're here today charged with a violation of the sex offender registry, and I want to make sure you understand your rights. It's indicated you want to enter a plea of nolo contendere, which means no contest. All that means is you're not going to admit you did anything wrong, but you're not going to deny it. And the state will then tell me what the facts would be if this went to trial, and I will use those facts to find you guilty according to this agreement. Do you understand that?
Yes, sir.
Have you seen or been shown a copy of these charges and talked them over with Mr. Hooper, and you and he discussed the range of punishments you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. Do you understand you can plead not guilty and have a speedy and public trial by jury in this court?
I just go ahead and plead guilty.
I know, but do you understand you can plead not guilty?
Yeah,
Do you understand if you pled not guilty, you have the right to have an attorney and to have one appointed, as I've done with a public defender?
yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you can appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
But that is going to result in a conviction. Do you understand that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest and give up your right to a trial?
Yeah.
Is your decision to plead no contest today voluntary?
Yep.
Anybody forcing you to do this against your will?
No.
Do you understand that I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
Then I want you to listen as the state comes to the podium and tells me what their evidence would be if this case went to trial.
If it's gone to trial, say, expect to show that Mr. McNear was subject to the Sex Offender and Violent Sex Offender Registration Act. And on or about February the 5th of 2024, the state expected to show that he established a new residence outside the state of Tennessee. He did not disclose that required information to the designated law enforcement agency, and the his whereabouts were currently at that time unknown to his supervising officer, Yvonne Weems, and she had not been advised of that new residence by Mr. McNear.
I'm not asking that you agree with those facts, Mr. McNear, but do you understand that's what the state's evidence would be if your case went to trial?
Yes, sir.
Do you still wish to plead no contest?
No, I just plead guilty and get it over with.
All right, well, we're not going to let you plead guilty because your lawyer says you've got to plead no contest.
Okay.
So I'm going to let you plead no contest.
No contest.
Even though I know you. In any event, are you satisfied with your attorney's services other than him making you plead no contest?
Yes, sir.
Do you feel like he's done a good job of representing you confidently?
Good job.
He's done a good job. All right. Mr. Hooper, do you know of any reason he should not enter this plea?
No, Your Honor.
Then Michael McNear, in docket number 15003, upon your plea of no contest to violation of the sex offender registry, I find you guilty, sentence you to 2 years in the Tennessee Department of Corrections to be served concurrently with your Hardin County sentence on the violation of probation. It will be suspended after you've served 1 year day for day with credit for time served.
Thank you.
Thank you. There you go.
Good morning, Your Honor. Robert Mediac, page 13 and 14.
Just back on Mr. McNear, I don't think we announced it, but he would get pretrial jail credits from August 29th.
It's on the document. So it was Mr. Hooper had it.
Okay, it was on there. I just want to make sure we got it on the document.
All right.
Correct.
All right, public defender represents Mr. McKeviak.
Yes, Judge. We were working towards settling that case along a certain line that didn't end up working out. So I think we can get it resolved this month. If we could just set it on the BOP day of 2/25, I'm confident.
All right, we're going to set it on February the 25th to allow for a final plea date or status. Lawyers working to try to resolve your case. We'll see you again later in the month.
Yes, sir.
Thank you.
Donald Miller, Your Honor, page 14.
All right, Mr. Miller is represented by the public defender. It says the trial date is the February the 28th and the last day to enter a plea is the 25th.
Yes, Judge, and we think we may have a resolution, so we could just keep it on the 25th.
I've received an offer, Judge. I think we got her.
All right, so I'm going to leave it set for trial on the 28th with the last day to plead is the 25th. Mr. Miller, your lawyer says that there's possible resolution. Just understand if you don't resolve your case by the 25th of this month, you will go to trial on the 28th. Thank you.
Yes, sir. Mark Mosley, Your Honor, page 15 and 16.
All Mosley here to be arraigned on an indictment charging you with assault, with bodily injury, child abuse, or neglect, and endangerment violation of no contact order. You're also charged in a second indictment, docket number 15050, with driving under the influence, second offense, and open container, driving while your license is revoked. And you're also charged in a third indictment with failure to appear. You have the right to an attorney on all of these charges. Do you wish to have a lawyer?
Public defender.
All right, public defender will be appointed based on his indigent status.
Wait, I'm reading the indictment, enter a plea of not guilty. Your
Plea of
Honor.
not guilty is entered. We need to set it for status 617. All right, your lawyer's been appointed. He's going to start working on your case. He'll be over to talk with you about this matter to get you ready for a possible resolution or a trial. So we'll see you again in June. Thank you.
Your Honor, tell me the date again on that, please. We wasn't clear on that.
June 17th, that's just for status. That allows him to get his discovery and allows the state and the defense to try to work it out. If they resolve the case by an agreement, then he can be pled out earlier than that. But if it's not resolved, then on June 17th, I will set him a trial date.
Thank you, Your Honor. Number 18, your Zachary Schottmer.
Mr. Knowles represents him. I think he's.
He did, or are you done?
Page 21.
He is. No, his contact, Warren, Your Honor, he's in court in Carroll County. He may make it back over here, but I believe the you present an offer to Mr.
Yeah,
Knowles.
we think we have it resolved, so we can
So-
second call it, Judge. If he doesn't get here, we'll put it on the 25th.
All right. We'll set it on the second call for later. Now, I have to leave probably 3:30 today because of.
If we don't get it, we put it on the 25th.
All right.
Actually,
We're going to come back to you. Your lawyer, they think they may have a resolution. We're going to give your lawyer time to try to get here from another court. Thank you.
Charles Shook, Your Honor, page 22.
It's just an arraignment on a superseding. He got set for status on 513.
You have a lawyer?
He does. Public defender represents him.
Okay. All right, public defender represents Mr. Shook. We have a superseding indictment to be arraigned upon.
Yes.
May 13th for status.
White former reading the indictment, enter a plea not guilty, Your Honor.
All right.
Judge, it's set for May 13th already for status, so we put it on that note.
All right, May 13th. Your lawyer's gotten a copy of the new indictment against you, the superseding indictment, and it's still set for May 13th for status. And if it's not resolved on that day, you can get a trial date. Thank you.
Drunton Smithson, Your Honor, page 22 and page 23.
Here's an attorney, Jonathan Turner.
I represent Mr.
All right.
Does he have a order that we agreed upon for a bond source?
All right, so it's here for a bond source hearing, and
Can you just set a trial date?
So Judge, we will need to put this on March the 11th for status. Judge Wallace heard some issues on this.
all right, March the 11th for status, and if it's not resolved on that day, Judge Wallace can give you a new trial date. So.
We'll get another, okay. So that's just for status.
Thank you, Your Honor.
We're not
Brandon
setting.
Walker,
it for
page
trial
24, Your Honor.
We're not setting it for trial until such time as we've had, make sure that there's all, the issues are resolved, all motions are heard, and there's discovery has been completed, and only then will we set it for trial. So,
Thank you, Judge.
all right, I'm sorry, I'm on page 24.
He's on page 22, I believe.
What is your name at the jail?
Brandon Walker, Your Honor, page 24.
All right, Brandon Walker. Walker, you're here, are you representing this individual? You're not, this is Mr. Walker's, not your case.
I'm just checking on the board.
Mr. Walker, you're here to be arraigned on a charge of possession of methamphetamine with intent, simple possession, resisting arrest, being an accessory after the fact, and possession of drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, ma'am.
Public defender?
White Paul written the indictment, enter plea of not guilty.
Plea of not guilty is entered. We need a
6/17, Judge.
June 17th for status. Your lawyer will be up to talk with you and get you ready for either a disposition or a trial date.
Thank you, Your Honor. Winchester, page 26, Your Honor. Leslie Winchester.
We can call that. Yep. Maybe able to resolve that.
All right, Mr. Leslie Roy Winchester, your lawyer and the state are still discussing your case, and we're going to put you on the second call and come back to you.
Yes,
Thank you.
Your Honor. Malia Barnes, Your Honor, page 2.
She's supposed to be in the trial, but Scott Saul represents, or excuse me. I thought Scott Saul was that Mark Ashton? Mark Ashton represents her on that.
Mr. Saul is here.
No, it's not Mr. Saul. It was
Okay.
Mark Ashton. I'm speaking.
Mark
to him
Atchison.
myself.
It's easy to confuse the two of them.
Yeah, sorry about that.
They look a lot alike.
They do, they favor.
They're twins. Then,
Your
Ms.
Honor,
Barnes, you were here today. I'm sorry.
this is Mr. Spratt. I'm supposed to be standing in for Mr. Atchison, so we'd waive formal reading, enter plea of not guilty on that arraignment.
All right. Plea of not guilty is entered. We'll have a copy of that arraignment entered. Sent to May 13th for status. If it's not resolved on that day, then a trial date can be assigned by the judge. Thank you.
Thank you, Your Honor.
Samantha Gardner, Your Honor, page 7.
All right. Samantha Garner, you're here to be arraigned on the charge of violation of probation. It's alleged that you were placed on probation on or about the 28th day of January 2024 for assault, bounty hunting violation, attempted possession of heroin, and possession of methamphetamine with intent for a period of 8 years, that you alleged to have violated your probation by having tested positive for amphetamine, methamphetamine, and MDMA on December the 2nd. You also have a balance of court costs and fines as well. So you have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, Your Honor.
All right, public defender will be appointed.
Enter plea of not guilty, Your Honor.
Plea of not guilty is entered. Do you want it set for this month, or do you want it set? I mean, we set it for the 25th of this month, or you can have it set for the following month, whatever you choose.
Let's just set it for this month, Your Honor. We'll set it.
All right, February 25th. Lawyer will be up to talk with you about your case.
Rachel Hartman, Your Honor, page 8.
Hartman, you hear the, oh, I'm sorry, you are represented by the public defender already?
Yes.
Yes, Judge. She's set for trial on the 28th. I guess we were operating under the understanding that she'd be on the 25th. So if we could just set her on the 25th, I believe we should be able to resolve.
All right, February 25th.
Thank you, Your Honor. Angela Put, Your Honor, page 19.
There's a pending motion to suppress, and we're going to reserve that this time.
You're going to reserve that motion?
Anticipation of settlement.
All right. Well, on page 19, Angela Putt. Ms. Putt, you're here to be arraigned on an indictment charging with simple possession or casual exchange, violation of motor vehicle ignition interlock device, introduction of contraband in a penal facility, possession of a Schedule 4 drugs, and possession of Schedule 3 drugs. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir. Yes.
Are you, public defender, have any reason you can't represent? Public defender is appointed.
White former reading the indictment, enter a plea of not guilty.
Plea of not guilty is entered.
March 11th, Judge.
March 11th for status. And we'll determine whether or not a trial date needs to be set on that day. Thank you.
She's got VOP set to 225. Do y'all want to go ahead and move those VOPs? Leave them on the 25th?
Leave those on the 25th and make this one.
Yes, sir.
All right. Your lawyer will be working with you, and we'll see you on the 25th of February.
Thank you.
Tanya Travis, Your Honor, page 23.
All right. I'll use Semra Christine Triplet.
I think it's time to try this. That's what he said.
Oh, I'm sorry. Tanya Travis, is that who you are? I'm sorry. Ms. Travis, you are here to be arraigned on an indictment charging with possession of methamphetamine with intent to sell or distribute, simple possession rather, and then possession of drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Public defender will be appointed.
White former reading the indictment, enter a plea of not guilty.
Plea of not guilty is entered.
June 17th.
June 17th for status. Your lawyer will be up to talk with you, get you ready for either a disposition by agreement or for a trial date. Thank you.
Thank you, Your Honor. Your Honor, I believe that concludes all of our in custody.
All right, thank you very much. We'll move then to the regular call of the docket.
What time would you like us to come back or come up, bring all the other ones over, Your Honor?
All right, thank you. Moving to page 1, docket number 15034, State versus Amy Angela.
Judge, she may still be at large. She was a new one and I'm having to turn.
Amy Angela. All right, we'll show her at large at this point.
Your Honor, if I may.
All right, hold on.
Hold on.
Hold on just a second.
She's not just living on them. Requires a large wheelchair. Not riding the car, et cetera, et cetera.
Let's just take it off. Let me just pass it and then we'll talk.
So, yeah, and so.
All right, we'll pass Miss Angela's case till later and I'll talk with the district attorney's office and the public defender about that case. Next case is docket number 14899 and L and follows, State versus Michael Scott Ayers.
Judge, they haven't amended this on Mr. Ayers. I have a copy of it here, but they should probably take it.
Mr. Ayers, you're here on a probation violation. We actually have a new warrant to for an amended violation of probation warrant to serve on you. And I'll give this to the officer and allow her to serve that on you, but you'll need to be taken into custody at this point in time. We'll need to have you step back in the back, but I need to first find out, are you wanting to have a lawyer represent you in this case? Yes. Are you able to hire a lawyer? I know at this point in time, you're about to go into custody on this new hold for a hearing violation of probation. So public defender.
Enter a plea of not guilty, Your Honor.
Plea of not guilty is entered. February the 25th will be the hearing date. And if you'll step back with the officers, they'll allow you to be processed. Docket number 14625B, State versus Angela Baker. Mr. Sanders.
Ms. Baker, along with her co-defendant, Mr. Stanfield, represented by Mr. Spratt, reference on Zoom. They're set for trial at the end of this month. We haven't resolved anything.
All right, remain set for trial. What is the trial date?
225.
226. 226. All right, set for trial at 226. This is the final day to enter a plea, so it will go to trial or it will plead, or the defendants will have to plead to every count of the indictment and go to sentencing. So matters are set for trial. They remain set for trial.
Thank you.
All right, thank you.
Is that February 26th?
February 26th.
Docket number 14993, State versus Cole Younger Baker. Mr. Baker.
And Judge, that one is set for trial on 2/26, and I think technically his last day of plea would be the 25th. But
Mr. Baker's gonna need to just receive discovery. He reset.
Do you know anything about Mr. Baker's case?
Oh, he was just in here. I'm sorry, Judge, I thought he was still in here. This case I just talked to him about, texted him, and he said he wanted more time to review discovery with his client. I did become aware of another body cam video yesterday. I just emailed Chief Edwards to ask if there was anything else outstanding.
Has Mr. Olin Baker left the building?
Your Honor, can you hear me?
I can hear you.
I'm sorry, Judge. I don't know how to operate this as well from the cell phone.
Is this Lee Spratt?
It is, Your Honor.
I'm not sure I've ever heard anybody so resigned to having to tell me who they are, but Mr. Spratt, I understand you are trying to operate remotely, so we'll work with you.
Yes, sir. I'm not feeling well this morning.
Sorry to hear that. So.
For Mr. Burnett, Mr. Baker has a waiver, an arraignment waiver that I have with me. It looks like there was a fact sheet. I don't know if Madam Clerk got that or not.
Everybody just bear with me. All right, Mr. Spratt, we're on page 3 of the docket, Kyle Lee Burnett, correct?
Yes, sir.
And there was a waiver filed by Olin Baker, so I'll take care of that. But we're gonna, and what we're gonna do, just go ahead and just deal with Mr. Burnett, since Mr. Spratt's online with us.
That's new arrangement.
Mr. Baker, just stand right there, sir.
So that'll go to June 17th.
June 17th will be the status day on Kyle Lee Burnett. All right, now we're gonna go back to who's standing in front of me right now, which is Cole Younger Baker, and that's Mr. Olin Baker's case as well. My understanding is that it's set for trial on the 26th, but there's been some discovery issue.
I just texted Mr. Baker, and he said that he wanted to reset it to June. I think that June 17th date.
Well, let's put it on the 25th of this month, and is there any reason you can't resolve it? Well, I guess June 17th, that's fine. Okay. June 17th. Your lawyer's working on it, but apparently he's gotten some new information, so it will be reset for status on June 17th. If it's not resolved on that day, we'll set you a final date for trial.
Thank you, Your
All
Honor.
right, thank you. Next looks like John Scott Bradley on page 2, document number 14782.
He said the 26th, so I think we thought his final plea date was the 25th.
it probably should be. I got carried away on my 211s, Judge.
I had him coming over or later for that resolve. I'd asked for him to be brought over, so we may be able to resolve.
Do you want him on the second call today?
Yes, sir.
Mr. Spratt?
Yes,
you're
sir.
not driving.
No, sir. I've been stationary for a while here, Your Honor.
All right. Well, that's fine. What else do you have that I can assist you with so that we can get you out of here?
Well, Your Honor, I have a few, and I tried to speak up when Mr. Sanders was up there earlier on page 23, the Spencer Stanfield case.
Well, I'm going to get Mr. Sanders back up here, so now you can speak up while he's at the podium.
Okay, and Mr. Sanders had tried to reach out to me yesterday. I was in a motion hearing with Judge Wallace and General Hornick fairly late yesterday evening. But those matters, I believe, are set for trial on the 26th. Is that, I think that's correct.
Yes.
I'm asking.
Spencer Stanfield on page 23, Judge.
Okay.
Yes, sir.
Angela, go to
Page 1.
I would ask that we, if the court will allow it, that we make the last day to plea the 25th.
I think that's where we were, Judge.
Yes, it should have been, yes.
Yeah, we're going to grant, I'm going to give you that consideration, and I'm going to set it for the last day to plea, the 25th.
Thank you, Your Honor. And Judge, just as a heads up, I may, and I spoke with General McLeod about this earlier, understanding full well that he would have to plead to the indictment after that day or go to trial. I may ask to continue that trial date due to the upcoming trial the following week that General Hornick and I have. And if I do that, I'll file a motion, but I need to take a look at some things. But I mean, I would acknowledge that the 25th would be the last day.
Okay. 25th.
If I've confused anything anymore.
That's all right. What else do you have?
Your Honor, may I address Mr. Spratt real?
Yeah, well, I'm going to put you two in a breakout room. Stand right there. Hello again, Mr. Spratt. Can you hear me?
I can, Your Honor.
All right.
I think I went to
We
the
have
breakout room alone.
We're just going to let you and Mr. Sanders have a one-on-one conversation with everybody in the courtroom listening in. So,
Mr. Spratt, earlier when Ms. Baker's case was called, and we took care of her matter, she left and a gentleman left with her. I don't know if that was Mr. Stanfield or not, your client, but if so, he hasn't been here to hear any of this. So I'll make sure that Ms. Baker knows what's happened the second time the case was called.
Thank you. And I'll reach out to my client and make sure that we can communicate that.
Yes.
do you have anything else?
I have
Do you have
quite
anything else?
I do,
You have
Your
quite
Honor.
a few.
I do, Your
Well,
Honor. And
let's take care of it so you can get back to where you need to be.
thank you, Judge. So on page 4 to through 5, Christopher Todd Dodson. There's several cases for Mr. Dodson, some of which are mine, some of which are Mr. Flanagan's.
Except for trial on Thursday, is that correct?
Judge, those are mine. My situation hadn't changed, so if we could get a.
I'm sorry, what?
My situation hadn't changed about this week, so if we can put them on the 25th.
All right, February 25th.
Your Honor, so that will, and it's a mixed bag on both sides. General McLeod, I believe, has the DUI case. So we're just going to put them all on the 25th, and because that'll alleviate. Okay, thank you, Your Honor.
What else you have?
On page 15, Your Honor, I have a Stephen Juan Morgan.
25th for now. If we could just leave it on the 25th.
All right, February the 25th for the last day to enter a plea.
Thank you, Your Honor. On page 20, I have a Darren Ring.
Mr. Ring is here.
He is here in the courtroom.
Okay. Your Honor, that's showing set for status. Mr. Ring obviously is now out on bond. He was previously serving a sentence from another county. So I think I heard the court was setting cases for status in June. This wasn't a last day to plea yet for him. I didn't.
State have any opposition to moving this to June 17th? June 17th, that'll be his final status and plea day.
Thank you, Your Honor.
If it's not resolved on that day, we'll set it for trial and he'll either go to trial or plead to the indictment.
Thank you, Your Honor. And then on page 21, I have Nathan Rumsey. He's should be in the courtroom there.
Got a new one to be arraigned on as well, Judge.
All right, Mr. Rumsey's here in the courtroom and we have a new arraignment for him for
Yes, Your
possession
Honor.
of drug.
Yes, Your
and
Honor.
violation of
I didn't file a waiver because Mr. Rumsey was going to be present anyway. So I am going to be attorney of record on the new case. So we'd waive formal reading, enter plea and not guilty as to count docket number 15054.
All right, we're not guilty as entered. What are we doing with all of these? Pardon? June 17th. That's going to be his final status and plea day will be June 17th. This is an attempted first degree murder, aggravated assault, vandalism. So it needs to be ready to go, either to work it out or be ready for a trial date to be set.
Yes, sir.
June
Thank
17th.
Thank you, Your Honor. And then finally, Judge, on page 22, I have Michael Simpson.
You know, that's for status, and we are awaiting one phone call from the county, Humphreys County, about some numbers. So we think we have that settled. If we set 25, we think we have that resolved.
All right, February 25th. We'll see you again, Mr. Simpson, on February 25th.
Oh, sorry.
Thank you, sir.
All right, thank you.
Your Honor, Mr. Pratt has one more he doesn't know about. Seal.
Yes.
Docket number 15059 on page 8.
All right, hold on, Mr. Spratt. We have a superseding indictment on Colin Scott Hanneman. You say it's on page 5.
It's
Page
yes,
8.
Page 8. It's just under seal and
That's one.
under seal until today.
All right. This is an indictment, Mr. Spratt, that charges Colin Scott Hanneman. It alleges that in the grand juries of Humphreys County, newly elected and panelists sworn find that about August 13th, 2016 and August 14th, 2016 in Humphreys County, Colin Scott Hanneman did unlawfully and feloniously sexually penetrate ABR, date of birth 1/5/1989, without her consent, causing her bodily injury in violation of TCA 3913-502, a Class A felony, all of which is against the peace and dignity of the state of Tennessee. Signed W.A. Crouch. So this.
We're not asking for a new bond. He's been in constant contact with Mr. Pratt and has made a bond. And
has this already got a status date?
Except for trial in front of Judge Wallace.
All right, except for trial in front of Judge Wallace. So I'm going to go ahead and leave it set for trial, but that is a superseding indictment. So you'll need to deal with Judge Wallace if you need anything done about that trial date, Mr. Spratt.
Thank you,
And
Your Honor.
what is the name? What is the name on that case?
Hanneman, Hanneman.
Thank you.
Everything then, Mr. Spratt?
Yes, sir. That should be it. I'll reach out to Madam Clerk to get a copy of that indictment fairly quick, so I can get back with Judge Wallace on that.
All right. Well, I hope you feel better. Get to where someplace you need to be.
Thank you, Your Honor. I appreciate it.
All right.
What time do you want the inmates brought over?
I guess 1 o'clock.
1 o'clock? Yes.
All right, we're going to go back through the docket then. Start again. You may have to help me remember where I was. Looks like we're on page 3, docket number 15039, State versus Tom Christopher Carroll.
That's my case. I have a waiver for his appearance. We'll waive formal reading, enter a plea of not guilty.
Plead not guilty as Henry. Mr. Wanick will be shown as the attorney. Legal status date,
6/17, Judge.
June 17th for status. Thank you.
Thank you, Judge. Judge, can I make an announcement?
Yes.
On behalf of Mr. Bill Morris, who just left, page 7. Last name is Elsie.
On top of page 7, Jason Edward Elsie,
Judge, that's just for status. I need to move that to March the 11th. That's my page.
March 11th.
Thank you.
Right. On top of page 4, docket number 14944, State versus Dana Conrad, public defender.
That is for plea. Earlier, I did not see Ms. Conrad at room 44 stars, and she hasn't signed this yet. Okay. Can we second call your honor the general?
Put it on second call. Docket number 14994, State versus Daniel Matthew Cunningham, public defender.
That's clear. This is and your honor, this is the one that I spoke to you earlier. There will be a reversion plea. The case that this is running concurrently with your honor is in Dixon County. He will be entering a plea to that tomorrow, which will also be a reversion.
Well, Mr. Cunningham, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
State your full name for the record.
Daniel Matthew Cunningham.
Mr. Cunningham, you're here today charged with a couple of offenses. Appears to be that they are drug related, and it's been indicated that because you have no prior record of any kind, that the state and your lawyer have worked out an agreement for you to enter this plea under what's called 4035-313, which is a part of the Tennessee Code that allows first offenders to have their case put on what we call a deferred basis. And this would be placing you on probation for 6 years, and that would be concurrent with your Dixon County case that you're going to be dealing with tomorrow. You would be ordered to pay a $2,000 fine, undergo an alcohol and drug assessment, follow the treatment recommendations, monthly drug screen for the entire sentence with zero tolerance for any failed screen. And the count 3 would be 11 months and 29 days in the county jail, suspended and concurrent, $150 fine and cost. Now, what this deferral means is that you're going to be on probation for 6 years. If you successfully complete your probation, then at the end of that time, you can ask the court to, won't necessarily be me or some other judge, you can ask to have that record expunged or wiped clean as though this never happened. By contrast, if you violate the terms of those and conditions of your probation, this will become a permanent conviction, and it will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. But not only that, but you could be brought back in and sentenced, re-sentenced within the range for this Class C felony that you're pleading to. Do you understand that? Do you understand everything you're charged with, and have you had an opportunity to review the charges and go over them with Mr. Hooper so that you fully understand what you're facing? Well, it's indicated that you want to enter a plea of nolo contendere. Do you understand that means you're not going to admit you did anything, but you're not going to deny it, and as a result, the state's going to tell me what their evidence will be if this case went to trial. You understand that I will use that evidence to find you guilty according to this agreement. You also understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court. You understand if you went to trial, you'd have the right to have a lawyer and to have one appointed if you could not afford your own. And of course, we've done that with a public defender. You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you can be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving, or pleading no contest, you're waiving your right to a trial and to an appeal? And all I'm going to do is approve what your lawyer's worked out.
Yes, sir.
You understand everything I've explained to you? You want to plead no contest and give up your right to a trial. Now, I've explained to you that if you successfully complete this probation, then you can have this expunged from your record. If not, then it will become a permanent conviction. You understand all of that? And actually, 2 convictions, 1 misdemeanor, 1 felony. Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? You understand I can't accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty of this charge. Then I want you to step aside and let the DA come to the podium and tell me what the facts would be if this case went to trial.
Your Honor, if this gone to trial, the state was expected to show that on February the 19th of 2024, agents from the 23rd Judicial District Drug Task Force were contacted by Dixon County Sheriff's deputies who had made a traffic stop on Mr. Cunningham, and they had found a substantial amount of Schedule 1 mushrooms. Along with the Schedule 1 mushrooms, there was a considerable amount of items that would be consistent with a grow operation. And they also discovered approximately 5 bags of bedding with mushrooms actively growing. Multiple ounces of mushrooms recovered along with marijuana. Mushrooms recovered were in a box that had his current address on it. Agent Freeze with the 23rd Judicial Task Force determined this was for resale. He got a search warrant for Mr. Cunningham's residence here in Humphreys County, and they did a search warrant and recovered items that were consistent with the grow and sale operation of Schedule 1 mushrooms.
Not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? You still wish to plead no contest according to this agreement. Is your are you satisfied with your attorney services? Do you feel like Mr. Hooper's done a good job of representing you competently? Mr. Hooper, do you know of any reason he should not enter this plea?
No, Your Honor.
And Daniel Cunningham, in docket number 14994, upon your plea of no contest to count 1, an amended charge of a Class C felony, order that you be placed on probation for a period of 6 years under 4035-313 of the Tennessee Code. And you'll be placed on probation for that period. This will be served concurrently with your Dixon County docket number 2024 CR 155 in order to pay the court costs and a $2,000 fine. As a condition of your probation, you're required to undergo an alcohol and drug assessment and follow all treatment recommendations and undergo monthly drug screens for the entire sentence with 0 tolerance for any failed screen. And count 3, you're found guilty, or you're rather placed on probation for 11 months and 29 days. That will be concurrent to count 1, a $150 fine and cost, and count 2 is dismissed as a part of the agreement. He needs to see the probation department before leaving.
Yes, sir.
Okay. Docket number 13422, State versus Timothy Stephen Dainsworth.
Your Honor, that is Mr. Dainsworth is Douglas Bates's case. Mr. Bates contacted me yesterday afternoon. He has the flu. I'm not sure if it's A or B, and so I took the privilege and said I didn't think he wanted him in the courtroom with the flu. Your Honor, that was set for tomorrow, but actually Judge Lockhart Mash there was also Unger case that Judge Lockhart Mash had heard, so and this was set in front of her, so we probably need to set that on 415, which is her.
All right. Mr. Dainsworth's case will be set for 4/15/25 status. And you're right, I don't want the flu, so, well,
I told him I would take the heat if he said he
I've had
did.
my shot, but I tend to want to avoid it. All right, let's see what we have next. Like the next would be on page 6, docket number 15005B, State versus Shelley Dunlap, public defender.
Yes, Judge, Ms. Dunlap is here today. This is one of those that was set for trial yesterday that got rolled to today. I have received an offer from the state, but I just need a little more time to discuss that with Ms. Dunlap. We roll that to 225 and see if we can't get it.
Any opposition to
No,
that?
sir, Your Honor.
February 25th. Docket number 14832, State versus Robin Adair Eaker.
Your Honor, that is Mr. Potter's case. Vanderbilt standing in for him. Your Honor, that is also another case that got set in front of Judge Locker Mash, and she'd actually heard some motions on it and some severance things we'd agreed to, so we probably need to put that on her 4/15 date.
All right, April 15th. Docket number 14922A, State versus Christopher Lee Gallup. Mr. Sanders.
Mr. Gallup, my client is here. His trial was yesterday, and I don't think he ever had a true settlement date. And so, please the court, I would ask the court to offer us a settlement date and followed by a trial date. I think we can resolve the case. An offer has been made. I'd like to discuss that with my
You want
client.
it on the 25th for your status and plea, or the 25th of this month?
Mr. Gallup indicates he's dealing with an illness within his family. I think it's his father. If it pleases the court, if we could have a little bit of additional time beyond that.
Is this a case I need to hear?
No, Judge, I think we're gonna settle it. It's just a drug case.
Well,
Put it on 4/15, Judge.
that's what I was going to say. We'll put it on April 15th.
Thank you. Sure, appreciate it.
And so that I know, that is a status.
That's a status and plea date for Judge Lockhart Nash.
Thank you, Your Honor. So the co-defendant, we can hear that later, Judge. I just thought.
You have a co-defendant?
Yes, Judge, on page 20, Ronald Reed. There's a little bit of, I've been in contact with Mr. Reed. There's a little bit of a communication mix up. I guess I told him that there was no court yesterday, but I neglected to tell him that everything got rolled for today.
So,
I've been in contact with him this morning. So we set this on the 25th and it's settled. Like
February 25th. Looks like then the next one is going to be docket number 13442B, State versus Thomas E. Hanna, Mr. Leonard's case.
And that's Mr. Jack Leonard's case, and he was going to be in Carroll County this morning, and he texted me on the way to court, and he woke up with what he believes to flu. But Mr. Hanna is Mr. Dainsworth's co-defendant, so it needed to be moved to 4/15 anyway.
April 15th, Mr. Hanna is here. The lawyers indicated he may have the flu, so he is not going to be here. We're going to reset the status on this case for April 15th. That'll be in front of a different judge.
And I'm going to text Mr. Leonard right now.
All right, thank you. Looks like then on page 8, docket number 15027B, State versus Robin Haskins. Mr. Patrick.
Please, court, Your Honor, I represent Ms. Haskins. She's present. Come on up, please. Ms. Haskins.
Robin Haskins.
Ms. Haskins. Come on up if you would, please. And Your Honor, she also has a co-defendant I represent, Mr. Penix, if you'd like to do both at once or both facts.
All right, what are we doing with this?
Status, we need plea and trial dates. Mr. Please, court, Mr. Penix come come join us. He's the co-defendant. I represent him.
Right. So you set for status, and we're going to set another status date. Do you want the June 17th date?
So June 17th is fine, but
Actually, I think that'll work. Status.
What were you going to say, General?
we'll go ahead and get a trial date as well, just in case we don't settle this. I don't know if Your Honor wants to. Just, it was, I think these came out of the grand jury in December.
They did.
They did, okay.
So you want to go ahead and set a trial date?
If Your Honor will do it, if not, that's.
I can set you a trial date.
And we can put it on the 20th.
On what day? June 20th?
Trial date?
We're going to give you a trial date.
That'll give you the 17th, 20th.
17th will be your last day to enter a plea. The trial date will be June the 20th.
Oh, correct. All right. Police court, I have one other one for status.
All right.
Dylan Neely. He has two different.
I believe Mr. Neely is currently.
He is. I'm not sure when he's getting out.
This new case, I believe, also came out the grand jury in December. So we should probably put him for status on the 17th as well.
What day?
June 17th for status, if that's okay, Judge.
No, let's just leave it at status because I don't want to see that. All right, that's all I have. Thank you, Your Honor. And my apologies about that. I'm going to try and turn my watch off and sit.
Modern technology is difficult for all of us of a certain age. So maybe you have somebody younger that can help you figure out how to turn it off. Well, I was going to have the bailiff turn it off for you. So. All right, next case is docket number 14997, State versus Daniel Heeman, Mr. Flanagan's case. So we'll put it on the second call.
He's here.
Well, never mind.
We're obviously not going to be trying it this week. It's a vehicular homicide, and it's a little bit unusual. It happened out at Loretta Lynn, so there's potentially a lot of witnesses.
Why are we not trying it this week?
Because we're not ready.
And the state's not ready either, Your Honor. The state has just received new evidence is coming in on this case. So, literally last week, and I have to provide that to Mr. Brown.
All right, so we just need to set it on June 17th for status.
Can we go ahead and get a trial date?
It's going to take, I mean, you know, from experience, I try them fast, but this will probably take 4 days. And there's that many witnesses. So,
Just if I'm looking at your calendar, we don't have a 4-day stretch on the calendar.
Well, we may have to reconfigure.
The closest I see, Judge, is October 8th, 9th, and 10th. That's 3 days. The docket calls the 7th. I may be looking at it wrong, Judge.
No, I think you're looking at it right.
that will give us Saturdays and then
Jury on Saturday.
I always want a jury on Saturday. They think you brought them here. They don't think I did.
Well, you think it will take, what's your estimate of the time?
I was thinking at least 3.
At least 3.
at least. But Mr. Flanagan has much more experience in these trials than I do, so I would defer to him.
Judge, I would say probably going to at least October, and it is Jeremy Fowles' case, but being familiar with, there are going to be a lot of out-of-state witnesses that the state will have to get here. As you well know, sometimes that can take some time, so I don't think we want to set it any probably sooner than October.
I hadn't thought about that. I agree, because there were so many out of town.
Because that was at motocross, Judge, so the majority of the witnesses probably would be.
Didn't I hear a motion on this? Or maybe not.
No, this one, I don't think. Might sign that bond. You might sign that bond.
Well, let's put it for the 8th, 9th, and 10th of October.
Thanks, Judge.
In 7 for plea, or when you want to set status soon with that? You want to put it-
No, let's put it on. Let's put it on the 7th for the last. We'll give you the last day of the plea will be the 7th of October. But obviously, if you get something resolved earlier than that, you can take it in front of a different judge, or get with me and we'll take you out of county if necessary.
Do we want to have a status on June 17th, or we taking that?
Status on June 17th, yes.
Yes. Thank you.
It's like on page 9, docket number 14999, State versus Jefferson, Luton, Jackson. This is a restitution issue.
Yes.
Can we second call this, Your Honor? She's got some.
Put on the second call. Same thing on Bobby James, 14807, State versus Bobby James, Douglas Bates the 4th. It's a motion
That's that.
for restoration. It's a restoration of rights. So is that something I have to hear?
Yes, sir.
Well, Judge, I think you recall, he filed a motion to restore his rights, and then we did a conference, and then you agreed, granted his motion. I did sign an order, and I've not done the research, but there was an issue about the gun rights being restored. And I think you asked Madam Clerk, when you looked at the order to place it for hearing, of course, Mr. Bates does have the flu today, so I'm going to put it on the 25th, June 20th.
Let's put it on the 25th. Maybe he'll have a review. I've gotten well.
So the reason you got to hear it, I guess, is because you ran.
No, he can come in by Zoom. Docket number 15043, State versus Curtis Chance Jones.
Please support Your Honor.
Plea of not guilty will be entered.
Thank you, Your Honor, and I'll keep my client appraised of all.
All right. Status
June
date
17th.
June 17th. That will be our status date. If he's not resolved on that day, we'll look at setting him for trial.
Thank you, Your Honor.
All right. You have a card that you want to give the clerk to make sure they have your address.
Absolutely.
Docket number 14950, State versus Faith M. Jones.
So she's in custody. We'll have to second call her whenever they bring her.
All right. Docket number 13729, State versus David Paul Kirkland.
one that you filed. You have to do something in a.
Oh, that's right, Judge.
Yes.
Judge, that's the case where we have a CAC interview, so we need to have a CAC hearing motion and then set a trial. I don't think you have to hear it necessarily. I don't think he's heard anything, has he?
I mean, it appears that we have the rest of this week available for hearing any of these motions that are set, considering the fact that we had trials set the rest of this week and none of them were going to go, correct?
Correct.
When you say we, I don't know that I'm ready, but
Well, we're talking about not a trial, but a
CAC
hearing on
motion.
child advocacy.
it's like a trial. You've done them. It takes all day.
Now, I could try to get witness here, but that's Mr. Plain's not ready. And then
Well, what day are we talking about?
Tomorrow, Thursday, or Friday.
I don't know that I can get witnesses here tomorrow, Judge.
That would leave you Thursday or Friday.
I can do it Friday.
It's Valentine's Day. It might be appropriate under the circumstances.
Well, I have to go to Robertson County first, though. I just noticed that.
The way things go, if you're going to Robertson County, you want to set it in front of a different judge. I don't have a problem with that.
Do we have a VOP day?
February 25th.
It's already getting pretty full to have an all-day motion.
Okay.
Let's put it on May 13th, Judge, and that'll give Judge Turnbow a good case.
That will be. May 13th.
And we'll do the motions on that day, and then that'll be a status.
That's perfect. That's my 40th birthday. There you go.
Oh, congratulations. May 13th. Let's take a mid-morning recess. We'll be in recess for 15 minutes.
All rise.
Your Honor.
All right, this is Mr. Jefferson Luton Jackson, and it's a restitution issue, and you wanted to move that to when?
The 25th.
February 25th.
Yes, sir.
Like we're at page 10, State versus Russell, Kansas Klein, Mr. Flanagan. What are we doing with Mr. Klein?
We need a trial.
Trial date?
If we get a plea day too, Your Honor, we think we might be able to settle it, but not 100% sure, so we do need to try.
So our new status for, and you don't assign a trial date until everything is past that point. We're just gonna toss it out the window and start going back to the old plea day and trial date.
Let's just do a status date because the civil case is kind of running.
The whole purpose, and I don't mean to be sarcastic, well, I guess I did. But the point of the new system is that we don't assign a trial date until all the negotiations have been concluded and the matter is ready for trial, all discovery and motions have been heard. And that way we avoid setting things for trial that are not going to go. And right now, when we're setting a trial date and then we say, well, we want a plea date, and I've already done it this morning against my better judgment. And what that means is that we're giving out a trial date when we have cases that absolutely are going to have to be tried. And we're giving trial dates out to cases that are likely going to end up being pled. So I'm more inclined to just give you a status
I meant
date.
to say I wanted a status date.
Did you say that already?
That's what I meant to say.
Yeah.
He was just confused.
I was confused.
So let's put you on June 17th for status. And then we will, at that point, if all the motions have been heard and all the negotiations and all the discovery has been completed, and I know that's a concurrent, that's a problem that you can't control if the crime lab or the law enforcement's not supplying everything until the last minute, but let's make sure everything's concluded before we set it for trial.
Yes, sir.
All right.
And Judge, while Mr. Flanagan is up there, on that same page, Thomas Lane was accomplished at Mason County Jail.
Yeah, we have Mr. Lane for status.
That's General Cloud, but I just saw it on the next.
He's in that, what I call the stadium case in Dixon County. We're gonna have to have a stadium to try them all. He's in that conspiracy case, so we can't really do anything with this yet.
All right, so because of the fact that he's in the multi-defendant, the 20 some odd defendant indictment, we're gonna need to set it on a different day. So what do you want to do as far as just put in a status date in June?
When's that?
I think he's open.
Status day in May.
We have a May date on all of those cases that are supposed to give us an opportunity to try to resolve it. So
And let's put this on June 7th.
June 17th. June 17th on Mr. Lane as well.
June 17th, yes.
Oh, sorry. Wait.
All right. Let's see. We've done the Jeremy Jacqueline.
We did that yesterday.
Did we do 14290 State versus Robert P. Mallon III, Jennifer Honeycutt?
Yeah, it's Mr. and Miss Honeycutt and Mr. Odell and Mr. You may recall, you may not. I know Mr. Mallon is in custody in Pennsylvania.
Right.
He's still in custody, serving a sentence in Pennsylvania. We have a detainer on him. We won't be able to do anything. Until then, if we can reach some resolution, we may be able to do it by Zoom while he's in custody, but we haven't.
We did one of those not in Dixon County not too long ago. Was that your case that we did?
I don't believe so.
I did one that was in federal prison Yeah, I think maybe Asherson or somebody arranged it for us to do it in federal. We put a guy out in federal prison.
Pennsylvania's been pretty cooperative, so if we could resolve it, we will, but otherwise we just need to put it on June 17th, I guess, Judge, kind of keep us going.
All right, June 17th.
Thank you.
Michael Marler, we set for in front of a different judge,
Yes,
correct?
415.
415. All right, then on page 12, Mr. Flanagan, you had Donald Matthews that was in jail. For status.
Got a lot of cases, he's been in jail a long time. We could put that on the VOP day. I just need to speak to Mr. Matthews. He's got so many things I need to explain to him.
He has 6 cases, including 2 failure to appear, so we'll put him on February the 28th.
Yes, sir.
Said the 28th, February 25th. All right, looks like now on page 14, State versus Brian Fletcher Miles, public defender.
Yeah, he's in custody. I'm asking for him to be brought over.
Oh, I'm sorry, I see he is in jail. All right, and we have Donald Shane Miller who's in jail.
He said the 25th, they're gonna bring him on the, or excuse me, the 28th, and they're supposed to maybe plea him on the 25th.
Okay. Page 15, State versus Ricky L. Mitchell, Mr. Baker. Who is Mr. Baker's surrogate today?
Your Honor, according to the document, the last day of police is the 25th, and he may be planning.
225. Docket number 15047, State versus John H. Moore.
Judge, we have a waiver.
Mr. Odell is the attorney for the defendant. Plea of not guilty is entered.
Knowledge received copy of the indictment, Your Honor.
Need a status date?
Yes, sir.
617.
6/17 for status.
Thank you.
You. Docket number 14746, State versus Zaniado Escalez Morales. Mr. Flanagan.
Need trial day, Judge. This one,
So
this will be tried.
this will be tried.
This will be tried.
All right.
Is this one? Yeah. He could be.
The problem with the Hickman County case is we can't get trial dates right now. So that, it's been holding up this case. I'll defer to the general. If he wants to put it on status date.
Judge, we can set it for. Can we put something on the 18th already?
18th, there's one case on June 18th.
What do we put that day?
Seemed like it was one case we did 7.
18th, Jeremy Jack Lynn.
That'll go, that'll. Judge, you don't have to hear this. Can we put it on March 11th?
Well,
That
that's
might
right.
be just quicker. All right.
Is that trial date, March 11th?
No, that'd be, that's just
Status.
good. That's just.
Just status.
Is that good?
It's status on
March 11th.
Hear that date? March 11th. Thank you.
Docket number 15048, State versus Jace Mortimer. Mr. Mortimer, you are here today to be arraigned on soliciting sexual exploitation of a minor under 13 years of age. You have the right to an attorney. Do you wish to have a lawyer represent you?
Judge, I think we could have, he could have an attorney status date. I've been talking to him. He needs time to try to hire a lawyer.
February the 25th. Well, let me put it this way. Well, I will arraign him, but how much time do you think you need to try to hire a lawyer? You're probably not going to be able to in a couple of weeks, I assume. Is that correct?
Judge, I was gonna put it on May 13th for Judge Turbo.
All right. We'll put it on May 13th. First of all, I can read you the terms of this and the language of this indictment, or I can give you this copy and let you read it yourself. Do you want me to read it to you? All right. So he's waived the formal reading of the indictment. We'll enter a plea of not guilty. I'm going to put this on May the 13th for attorney status. Be at 9 o'clock. So be back here and let it report to Judge Turnbow who you've hired as a lawyer. Okay. All right. Thank you. Looks like we're now on page 16, 14932, State versus Felicia Rose Mullins.
That's one Mr. Hooper and I talked to you about. We could put that on status for May 13th.
May 13th for status. Docket number 14801, State versus Dylan Scott Neely. That was Mr. Patrick's
We
case.
did that one already,
Thank you.
617.
One 14802, State versus Tara Lynn Neely.
Judge, Ms. Neely is Mr. Hooper's client, and she is along with Mr. Lanny, his client, Mr. Oliphant. They are set for the 13th. Mr. Hooper, of course, knows not to talk to Your Honor. I'll talk to Mr. Lanny a little bit, but I wasn't going to be ready this week on those. So if we could put those on March the 11th, is that all right?
March the 11th. State versus Anthony Ronald Nyhoff. Mr. Sanders.
Your Honor, that case is for status, and if we could put that on, we say March or May? It's May 13th, Your Honor, in front of Judge Turnbull.
May 13th.
Get a trial for that.
May 13th for status and to assign a trial date.
Thank you, Judge.
And then David Oliphant is the one we just set for May 13th as well, correct?
May 13th or 311?
311.
I'm sorry, 311. My mistake. Docket number 15026, State versus Devin Greer Polk. Mr. Vandervoort.
Is that set for status today? Just going discussion, we will set for.
No.
Yeah, we said for June 17th.
June 17th, we move it. What's sooner than May 13th? May 13th.
What day are we setting it?
May 13th.
May 13th.
Just a status first.
May 13th.
Thank you, Your Honor.
Docket number one, let's see, Ms. Parker is in jail. Brittany Shea Parker, do we have her in jail?
Yes.
She's gonna be brought over.
That'll be later on.
Yeah. Looks like on page 19, docket number 15005A, State versus Tommy Lee Pulley, or Tommy L. Pulley, Mr. Saul.
Judge, Mr. Pulley.
That's Mr. Saul's case. Mr. Pulley, he's a co-defendant on Miss Dunlap, and we set her for the 25th. But if we could put this one, we need some more time on this to put it to May the 13th. Miss Pulley, we think, is going to plead on the 25th, maybe. But if not, we can move it.
All right, May 13th.
Thank you, Judge.
Docket number 15004, State versus Carlos Hector Quillen. Public defender.
We second call this to the general argument. We may be able to resolve it today. If not, we'll move this.
Second call.
Thank you, Your Honor.
Page 20, docket number 15006, State versus Heather N. Renner.
Yes, Judge. So that's my case. Looks like it was set for trial on the 28th of this month. It's the first setting. We were appointed in December. My understanding is Ms. Renner's in the Henderson County Jail, but she's got a case out there as well as a case in McNairy County. I think it might be best to set this out to the court's next term, so that way she can handle all of that, and it would just for logistical reasons be easier to do it that way, I think. So I just asked that it be reset. That's that far an objection from the state of the court's April docket or June docket, I guess. June probably better.
All right, June 17th.
But I do think we might be able to get this one done.
Okay.
I'm reserving I filed a motion in limine in this. I'll reserve it pending settlement.
14984, State versus Billy Jack Repligal, public defender.
Your Honor,
Yes.
Mr. Provost for Repligal.
Oh, yeah.
That, Your Honor, he had cases in General Sessions Court that this was resolved. The state's going to nolly this case, if I understand.
Yes, Your Honor, I'll present you the knowledge.
You're going to dismiss this case?
Yes.
All right.
That was part of the settlement for General Sessions.
All right, case is dismissed. 15053, State versus Miguel Angel Rodriguez. Look. ¿Se habla inglés? Okay. Mr. Miguel, Mr. Rodriguez, you are here to be arraigned on a charge of possession of drug paraphernalia. It's a misdemeanor. You have the right to an attorney. Do you wish to have a lawyer represent you? Are you wanting a public defender? In order to get a public defender, you need to raise your right hand and be placed under oath so I can find out whether you qualify.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
We're going to give you a form to fill out that you have to fill out an affidavit showing what your income and expenses are so I can determine whether you qualify. You can have an attorney appointed if you were indigent. So let's see whether or not you qualify. When you sign this, you'll be signing it under oath to make sure it's accurate. I'll come back to you later in the day. Let's see. The next one, it looks like that we had the Singleton case for Mr. Asterson, but what did we do with that Singleton case on page 22? Nicholas Alexander Singleton.
We had to call that one, that I know of, Judge. It's set for.
It was Mr. Asterson's case.
Quick a second, call it, Judge. I was just talking to Mr. Atchison. It looked like he was here somewhere, but I don't see him in the courtroom.
I saw it earlier on.
So the attorney or the defendant?
The attorney.
I'll tell him to come in.
On that first, on page 21, we got that Zachary Schottner. He was in the Dixon County Jail, but Mr. Knowles is here now. We were second calling.
No, I'm sorry. Zachary Thomas Schottner.
Judge, I think he may be present here in Humphreys County Jail now. Is that?
Oh, is he? Okay.
Could we have him brought over?
If he's here, we can have him brought over at 1 o'clock.
I'll tell Miss Angel.
I'll tell her.
Will you tell him? Thank you.
I'm on page 23. Smithson, we set that for 311. All right, so it looks like page 23, State versus Julie J. Stewart.
Judge, that was to be dismissed if she paid the cost. I'll check at the break, but as of the day I ran the docket, she had not paid that.
All right, then issue a show cause order for her to appear on the 25th of February.
Yes.
If she doesn't appear on that day, we will issue a warrant for her arrest. Docket number 15055, State versus Amanda Donette Travis. Travis, you are here to be arraigned on a charge of driving under the influence by allowing someone under the influence to operate your motor vehicle. You have the right to an attorney. Do you wish to have a lawyer? Are you planning on hiring a lawyer? Are you able to hire a lawyer? Raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth so help you God. Thank
I'm going to give you an affidavit that you're going to need to fill out, and you'll be signing it under oath to make sure it is absolutely accurate, and I'll come back to see whether or not you're qualified. And did we deal with Mr. Semra Christine Triplett, Mr. Flanagan? Trial date is the 28th.
25th.
Last day of the plea is the 25th. You want to leave it on the 25th? 225. Docket number 15033, State versus Spencer Tucker.
you. Judge, that was just an appeal out of for a traffic citation.
To be set.
He called and said he couldn't come today, so we just told him if he wasn't here, he would probably.
Case is dismissed. The appeal is dismissed.
Yes, sir.
Julio
Cesar Valenzuela.
Your Honor, he is Mr. Valenzuela, represented by Mr. Overton. I've not talked to Mr. Overton, but he was transferred into custody, into federal custody, and they have settled that case. So I'll be doing knowledge.
So are you nollying it today?
I will, and I'll get you an order.
All right. Case is dismissed. Thank you. Docket number 14916, State versus Jessica Renee Wallace. Mr. Flanagan.
Judge, this may end up being tried, but this might be a case to put on March 11th, Judge Turnbow.
That'd be May 13th.
May 13th.
May 13th. Okay. May 13th it is. Mr. Flanagan, you have James Eric Warden, which we called while he was in the Dixon County Jail. We have a superseding indictment. You wish a formal reading of that?
No, sir.
Right. Vehicular homicide, driver intoxication, aggravated vehicular homicide, reckless endangerment, Schedule 6 drugs, possession of Schedule 1 drugs, possession of Schedule 2 drug, methamphetamine, and Schedule 4 drugs, possession of firearm with intent to go on.
Charge.
That's, I see. Okay. They would wait for him, arraignment, enter plea, and not guilty.
You want to set it on June 17th for status?
It's already
It's set
set.
for trial.
We have a trial.
April 21st.
April 21st?
Yes.
Oh, okay. April 21st it is.
Not for me. No, I got to come. That's all right.
I'm gonna mutter it, just mutter it further away so I don't have to hear it. So. Docket number 15008, State versus Shane Wheatcroft, Mr. Bradley.
Yes, Your Honor.
Set for trial on the 13th.
Yes, Judge, and I've sent a plea offer to Mr. Bradley. And this case is a little complicated in the sense that the victim and the defendant are going through a divorce, and the papers have been signed. And as part of that, we anticipate being able to solve the case. However, we haven't got everything finalized yet. And we wonder if we could put on 225. I know that's past the trial date, but we really do believe that we are going to settle this case.
Yes, we are, you know.
I've spoken to the victim multiple times.
She has a lawyer and I've dealt with him, but Judge Douglas in Lexington, Tennessee.
He showed me.
Sent me papers. We got them signed by both parties.
All right. So February 25th?
Yes, sir.
Thank you.
Docket number 14960, State versus Bobby Daniel White, Mr. Lockard.
Yes, sir. I don't think he's made it back yet, so he's in that other court. I think you just need to
He
do
went to
dates.
me.
for status.
So what are we doing with it?
Thank you.
Status date of June 17th.
June 17th.
June 17th. Did we deal with Leslie Roy Winchester? It was the second call on restitution. William Blake Winters, Mr. Winnick.
We're still trying to work out some discovery.
On Mr. Winters, Your Honor, that case is separate trial, but Mr. Wayne reached out to me the other day. He'd been provided some videos in discovery, indicated he couldn't open those. So when I went back into my videos, I could not open those either. So we have requested those, along with another video that I had not been made privy to by the Sheriff's Department. That I think it was an oversight to try to get those. So there's some discovery out there. And this was one of those that was set up the old schedule, I think. So we could set it to June 17th and we could
June
make sure
17th.
everything's resolved.
All right. June 17th for status. Now, I've gone through this document one time. Is there anyone who had a case that you understood you were supposed to be here and your case has not been called? Come up. What's your name?
John Brewer. He's at the top of page 3, Judge. Would you speak to 15035?
Brewer, you're here on a charge of driving under the influence of an intoxicant violation of the implied consent law. You have the right to an attorney. Do you wish to have a lawyer represent you?
I'm probably gonna hire a lawyer.
You are going to hire a lawyer?
Yes, sir.
I can read this indictment to you, or you can read it yourself when I give you a copy. Do you want me to read it to you in open court, or you want to read it yourself?
I can read it myself.
All right, shall we waive the formal reading of the indictment? We'll enter a plea of not guilty. When do we want to set the status, please?
June 17th.
June 17th for status. That will be at 9 o'clock. And that's when you need to have your attorney hired, okay?
Yes, sir.
Thank you. Anyone else who has a case that's not been called? Let's go back then to the two that requested the counsel. Miguel Angel Rodriguez. Rodriguez, you're stating here that you are not working anywhere and have no income. Is that correct? And how are you able to live if you don't have any income? You're living with your brother?
His father.
Father? All right, I find he is indigent. Appoint the public defender to represent him.
This judge, we acknowledge the appointment, as well as receipt of the indictment, waive formal reading, and enter a plea of not guilty.
Plea of not guilty is entered. Need a status date?
3/11.
3/11 for status. Amanda Travis. You're not working either, Ms. Travis?
No, sir.
How are you able to live if you don't have an income?
I live with my mother, so I take care of her.
Swear this information is true and correct. Do you swear this is information is true and correct? All right, I'll report the public defender.
Yes, Judge, We acknowledge the appointment as well as receipt of the indictment, waive formal reading, and enter a plea of not guilty at this time.
Judge.
Well, Judge, this is co-defendant on the Brewer case we were just appointed to.
But not necessarily co-defendant, but she's
Is the,
Mr. Brewer that you just appointed public defender on.
It's the DUI for this DUI by.
This is the DUI by allowing him to drive, so I think they would have a conflict.
I'd say that would be a conflict. Mr. Odell?
Oh, wait, hold on. He was gonna hire a lawyer, my bad.
Oh,
That was
sorry.
Rodriguez we were appointed to, I'm
Judge
sorry.
Rodriguez, I'm
Sit
sorry.
down, Mr. Odell.
Sorry. We're good. Sorry about that.
I was really happy to see how quickly you got up.
He did jump pretty good.
All right, we will appoint the public defender since the other lawyer was, other is gonna hire a lawyer.
Yes, sir.
All right.
What's that?
And the status date was
6/17, Judge.
6/17.
Thank you, Judge.
Anyone else who has a case that was set for hearing this morning has not been called? Anything else I can take up before we break the law?
Conrad is for plea, Your Honor.
Bring him up. We are ready.
Yeah.
I didn't know.
I tried to pull it because I know she's
All right, I've been handed two different plea sheets. The first plea sheet in docket number 14944, Mr. Conrad will be entering a plea of no contest to count one. He received a sentence of 11 months and 29 days, suspended at probation, $750 fine, and she will be placed on the methamphetamine registry. Docket number 14945, upon her plea of no contest to count one, she would be found guilty, sentenced to 11 months and 29 days, consecutive to count one, $750 fine, and cost being placed on the count on the methamphetamine registry. Is that suspended?
Yes.
It doesn't say that. It just says 11/29 consecutive.
It's suspended to probation, consecutive to the other case. Sorry, I did not.
Count three is driving on a revoked license, 11 months, 29 days, suspended to probation, concurrent to count one, $50 fine. Ms. Conrad, raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank
State your full name for the record.
you.
Ms. Conrad, you're here today on two different indictments with a number of different counts, but have you seen or been shown a copy of all those charges? Talked them over with Mr. Hooper and you, and he discussed the range of punishment you're facing as well as any possible defenses you might have. While it's indicated that you want to enter a plea of no contest or nolo contendere, that means you understand what the state's evidence is. You're not going to admit you did anything wrong, but you're not going to deny it. And the state's going to then tell me what their evidence would be in this case, but then I will find you guilty based upon that evidence. Do you understand that? Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand that you would be entitled to have a lawyer and to have one appointed if you cannot afford your own. Of course, we've done that with a public defender. You understand that if you went to trial, you and your lawyer you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand that at trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out with the state. That's going to require you to be on probation for 2 years. Is that how it factors in? For approximately 2 years. You understand that, and that's going to result in 3 different convictions being on your record, all misdemeanors, but they'll be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. Do you understand everything I've explained? Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal? Is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty. and listen as the state tells me what their evidence would be if this case went to trial. Step aside and let Mr. Warner come up, please.
Your Honor, this has gone to trial on docket number 14944. The state was shown that on March the 3rd of 2023, McEwen City Officer Lee Miller received information pertaining to a person with an active warrant living in McEwen on Blair Boulevard. On arrival, he made contact with the homeowner, who stated that the subject was not inside but gave consent to search the residence. Ms. Conrad, in plain view, observed a baggie with white crystal-like substance inside, several other baggies with white residue of scale and cut straw. He observed her place a small black plastic card wallet down on the bed from her hands, and inside the card was a baggie of white crystal residue. The total approximate weight, counting the bag, 1.4 grams. She admitted to using meth approximately 1 day ago on that day. In docket number 14945, state had gone to trial. The state would expect to show that on August the 5th, 2023, Chief Deputy Lee Miller observed a vehicle traveling east on Highway 70 at a speed greater than the posted speed limit. Radar confirmed the car was doing 47 and 30, so he conducted a traffic stop. Ms. Conrad was driving on a revoked license due to an unsatisfied judgment. During the tow inventory, a glass pipe containing white crystal-like substance was located in the center console, and a $1 bill located inside a wallet containing approximately 1 gram of white crystal-like substance that the defendant admitted was methamphetamine.
Ms. Conrad, I'm not asking that you agree with those terms, but you understand that's what the state's evidence would be if this case went to trial.
Yes, sir.
You still wish to plead no contest according to this agreement. Are you satisfied with your attorney services? I believe Mr. Hooper's done a good job of representing you competently. Mr. Hooper, do you know of any reasons you should not enter these pleas?
No, Your Honor.
Anything further from the state?
No, sir, Your Honor.
Then Dana Conrad and docket number 14944, upon your plea of no contest to count 1, I find you guilty, sentence you to 11 months and 29 days in the county jail that will be suspended to probation. You're ordered to pay a $750 fine, and you're ordered to be placed on the methamphetamine registry. Count 2 is dismissed as a part of the agreement. Docket number 14945, you're found guilty of count 1, sentenced to 11 months and 29 days in the county jail that will be suspended to probation. That will be consecutive to the prior case. And you're ordered to pay the court costs, $750 fine and costs. And you're ordered to be on the methamphetamine registry in that case as well. Count 2 is dismissed. Count 3, you're found guilty, sentenced to 11 months and 29 days in the county jail, suspended to probation. That will be concurrent to count 1 in this case, a $50 fine and cost. So you need to see the probation department. Anybody have anything else that I can take up before we bring the jail cases over? We will recess for lunch until 12. Can we get to jail here by 12:30?
Yes, actually, they've already asked me if they could bring it in, so I said yes.
Yeah, well, as soon as 12:30 is your time. So. All right, we'll be at recess until 12:30.
All rise.
All right, easier for you to. Tell me who you got and what you got worked out. Mr. Atchison?
Judge, this is in reference to State v. Nicholas Singleton. Mr. Singleton is present. Judge, based on our conversation earlier, spoke with General McLeod. We're in agreement to place the motion to suppress
On Friday morning?
Friday morning.
14th. We're going to do the motion to suppress that Mr. Atchison is filing on Friday morning, the 14th. That was the first available day they can find.
And Judge,
It will
I'll
not
have,
be a jury trial that day. It will just be the motion to suppress.
Okay.
Judge, I'll have that motion to General McLeod once I leave and get back to my office.
And Ms. Billingsley, if you want to come in on Zoom, that would be fine. If you want to be here.
Is it a lengthy motion to suppress or?
It's
about an hour.
I think it'll take about an hour. It's the first day we can do it, unless we do it on the 25th. I don't know.
Oh, I can do it on Friday. I'm just, I mean, I may or may.
What do we have on, how much do we have on the 25th right now? Do we know?
It's a pretty, I think we reset.
Well, I think it would be safer to do it Friday since we're not having a trial. So. Right.
And I'm sorry, who was this on?
Nicholas Singleton, 14957.
Judge, do we want to start right at 9 or?
You have someplace else you need to be. Normally court starts at 9, so yeah, we'll start at 9.
You gotta go get that candy and flowers for your wife.
That better be done on its own already.
All right.
Thank you, Judge.
Knowles, you have something?
Yes, Your Honor. Judge, I have Mr. Zachary Schomeyer. Schomeyer, sorry.
21.
Page 21 in docket number 14890.
That would be, Your Honor, for changing for these.
All right, I've been handed a document indicating that Mr. Schottmeyer is going to enter a plea of guilty to count 1 of the indictment, attempted possession of a firearm during a dangerous felony, Class E felony, receive a sentence of 2 years to Department of Corrections to serve. That will be concurrent with the Dixon County violation of probation. He'll forfeit the weapon to Humphreys County Sheriff's. Count 2, he'll receive a sentence of 8 years to serve. This sentence will be concurrent with the Dixon County DOP. And count 1 and $2,000 fine. Counts 3, 4, and 5 will be dismissed. Raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony I give in this case should be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record. Mr. Schaumer, you were here today on 2 different, or actually 2 different, 1 indictment, but 5 different counts. Have you seen or been shown a copy of those charges? Talked them over with Mr. Knowles, you and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, it's indicated you want to enter a plea of guilty to those charges that I've noted. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury? You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own. You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by using a subpoena? You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal? You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer's worked out. Now, that's going to require you to serve an 8-year sentence. And you understand I'm giving you an 8-year sentence. How much of that you actually have to serve under the department's regulations is up to them. That's not a part of what we're doing. As far as I'm concerned, you served 8 years. You understand that? You understand everything I've explained to you. Do you want to waive your right to a trial and to an appeal and enter a plea of guilty according to this agreement? Do you understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer these questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we learned that you were lying under oath. Is your decision to plead guilty today voluntary? Anybody forcing you to do this against your will? No. You understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are guilty of these charges. And tell me, are you in fact guilty of this possession of a firearm or attempted possession of a firearm during a dangerous felony? And did you have that weapon with you when you were in possession of methamphetamine over 5.5 grams? All right. Any other factual basis for it, General, that needs to be explained?
No, sir.
Are you satisfied with your attorney services?
Yes.
You feel like Mr. Knowles has done a good job of representing you competently? Mr. Knowles, do you know of any reason you should not enter this plea?
No, Your Honor.
Then, is there anything further from the state? Zachary Schottmer in docket number 14890, upon your plea of guilty to count 1, I find you guilty of attempted possession of a firearm during a dangerous felony, sentence you to 2 years in the Tennessee Department of Corrections to serve. That sentence will be served concurrently with your Dixon County violation of probation. The weapon is forfeited to Humphreys County Sheriff. Count 2, you're found guilty, sentenced to 8 years in the Tennessee Department of Corrections to serve. Again, will be served concurrently with your Dixon County violation of probation. And with count 1, you want to pay a $2,000 fine. Counts 3, 4, and 5 are dismissed as a part of the agreement. Pre-sentence jail credits will be from November 13th, 2023 until today. All right, thank you. Mr. Knowles, you have anything else?
No, Your Honor, nothing further.
All right, thank you. Mr. Sensing, you have any matter that I can take up?
I do, Judge. First matter on page 9 of the court's docket, State versus Faith Marie Jones. That would be docket number 14950. She's approaching the podium now, and I do have a plea petition I'm tendering that I've gone over with her, in which Ms. Jones would be pleading no contest to count 1, false report amended to criminal impersonation, class A misdemeanor, for which she would receive a sentence of 11 months and 29 days, suspended to time served with the balance on probation. She would be ordered to pay costs, and as a condition of her probation, she must pass all drug screens with 0 tolerance for failed drug screens. She would also be pleading no contest to count 2, which is simple possession. She would receive 11 months and 29 days concurrent to count 1, suspended to time served with the balance on probation, $750 fine plus costs. And again, she'd have to pass any drug screens with 0 tolerance for failures. Count 3 would be dismissed in settlement, and she would receive jail credits from 5/11/24 to 6/12/24, which would be the minimum for the meth charge. And just for the record, I have spoken with Ms. Jones about the fact that she does have a Rutherford County case as well, so she'll be transported back there to deal with that, but that she's report to Mr. James after she's released.
Ms. Jones, step up to the microphone there. I know it's difficult. Raise your right hand to the best of your ability.
You solemnly swear or affirm that the testimony should I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Faith Marie Jones.
Ms. Jones, you're here today and you heard your lawyer explain what the agreement is, but have you seen or been shown a copy of those charges talked over with Mr. Sensing? You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated you want to enter a plea of no contest or no contender. That simply means you understand what the state's evidence is going to be, but you're not going to admit you did anything, but you're not going to deny it. And the state will then tell me what their evidence will be at trial, and I'm going to use that to find you guilty according to this agreement. Do you understand that?
Yes, sir.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court. At trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender. Do you understand that? You understand that at trial you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict must be unanimous before you could be convicted of anything. Do you understand that at trial, you and your lawyer can confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena? Do you understand that at trial, you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal? Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is prove what your lawyers worked out.
Yes, sir.
You understand that's going to result in 2 convictions, both misdemeanors, but they will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty to this charge? No contest to these charges according to this agreement and waive your right to a trial?
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
Yes.
Do you understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Yes.
General,
Yes, Judge. If this case had gone to trial, the state would expect.
you will step aside, let her come to the microphone so we have a record of it.
Judge, if this case had gone to trial, the state would expect to be able to show that back on May 11, 2024, Deputy Wooten of the Humphreys County Sheriff's Office responded to the McDonald's and Hurricane Mills for a report of a suspicious vehicle that had been sitting there for some time. He got there, he contacted 2 individuals in the car, one of which was Miss Jones, who, when asked for her identification, gave a fake name. Was not her. Furthermore, when she was being transferred to the jail, they found some methamphetamine in her person.
Ms. Jones, I'm not asking that you agree with those facts, but do you understand that's what the state would attempt to prove at trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Very much.
Do you feel like Mr. Sensing's done a good job of representing you confidently? Mr. Sensing, do you know of any reasons you should not enter this plea?
I do not.
Anything further from the state?
No, Your
Then Faith Marie Jones in docket number 14950, upon your plea of no contest to count 1, I find you guilty, sentence you to 11 months and 29 days in the county jail, suspended on time served with a balance on probation. You are ordered to pay the court costs. You must pass all drug screens with a 0 tolerance for any positive drug screen. That means 1 positive drug screen, you're going back to jail. You understand that?
Yes, sir.
Count 2, you're found guilty, sentenced to 11 months and 29 days in the county jail that would be suspended on time served, and concurrent with count 1, it would be a $750 fine and costs. Must pass all drug screens with a 0 tolerance, and count 3 is dismissed as a part of the agreement. So you'll need to see the probation department.
Thank you.
I've got some very,
Mr. Hooper?
Miss Parker, Brittany Parker. This will be a drug court plea. I think I've caught all the signatures.
Parker, if you'll raise your right hand, let's place you under oath.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. Thank you.
So that we're clear, because this is a recurring problem. She's going to be entering a plea of guilty and then be put on probation immediately.
Yes.
And then she, as a condition of her probation, will be that she complete the drug court and that she'll stay in jail until she's picked up by drug court to be taken to rehabilitation.
Yes. With what, just so the court's aware, she's going back to Williamson County to enter a plea on Friday that will also include our drug court. And they are aware to pick her up from there, and she will be attending synergy.
That's fine. This is worded the way I think it should be, and that it's going to be, she's placed on probation immediately. And as a condition of that, she has to then complete the drug court program.
Yes, Your Honor.
All right, Ms. Parker, state your full name if you haven't already. I'm sorry.
Brittany Shea Hayes Parker.
Ms. Parker, you're here today with a 3-count indictment. It's been indicated you're going to plead no contest to count 1, possession of methamphetamine with intent, and receive a sentence of 8 years Tennessee Department of Corrections that will be suspended to probation, and you're ordered to pay a $2,000 fine and costs conditioned on your completing the drug court, entering and completing successfully your drug court program. But have you seen or been shown a copy of those charges and talked them over with Mr. Hooper, find out and discuss whether or not, I'm sorry, and so that you fully understand what you're facing and what the range of punishment is and any possible defenses you might have? Well, it's indicated you want to plead no contest. That simply means you understand what the state's evidence is going to be when they tell me, and you're not going to admit you did anything wrong, but you're not going to deny it. And as a result, the state's going to tell me what their evidence would be if this case went to trial. And that's the evidence I will use to find you guilty according to this agreement. Do you understand that? Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand at trial you would have the right to have a lawyer and to have one appointed, as we've done with a public defender. You understand at trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state called to testify against you, and you can bring in your own witnesses by use of a subpoena. You understand that trial you and your you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is to prove what your lawyer has worked out. And you understand that's going to result in a conviction that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand everything I've explained to you. Do you want to waive your right to a trial and to an appeal by entering this plea according to this agreement? Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty.
Yes, sir.
And listen as the state tells me what their evidence would be if this case went to trial.
Yes, Judge, if this case had gone to trial, the state would expect to be able to show that on November 1st of 2023, Deputy Lasner with the Humphreys County Sheriff's Office stopped a vehicle with a pilot located off of Highway 13 south of Humphreys County. He had noticed that an expired registration, the license plate that was affixed to the vehicle did not belong to it. So he pulled them over, he talked to them, he conducted a search of the vehicle, and eventually discovered felony amount of meth in the vehicle, which belonged to Ms. Parker along with two other co-workers.
All right, Ms. Parker, I'm not asking you to agree with those facts, but do you understand that's what the state would prove at trial? You can step back from that microphone.
Yes.
Do you still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Hooper's done a good job of representing you competently?
Yes,
You
sir.
feel like he's done a good job? Mr. Hooper, do you know of any reason she should not enter this plea?
No.
Then Brittany Parker and docket number 14933, upon your plea of no contest to count 1, counts 2 and 3 are dismissed. Find you guilty, sentence you to 8 years Tennessee Department of Corrections, suspended to probation. You're ordered to pay a $2,500 fine and cost. You're also ordered to undergo an alcohol and drug assessment and follow the treatment recommendations. The condition of your probation is that you must complete the drug court program and you will remain in jail until you're picked up by the drug court rehabilitation or drug court for rehabilitation. I've been handed a document called a recovery court entry order. Have you read this order? Have you and Mr. Hooper discussed all of the rights that you are giving up and you're waiving the right to all of these different rights that you would normally be entitled to under the Constitution? You're giving up all of those rights in order to enter into this program. Do you understand that? They're pretty much going to run your life for the next however long. Then based on her acknowledgement that she has read through and understands all of the rights that she's waiving, I will order that she be entered as a drug court participant. So. Did you have an order for a furlough?
She won't be furloughed.
Okay, that's right. She's on probation. Never mind. Thank you for that reminder.
Yes, sir.
Right, good luck to you, Ms. Parker.
Thank you. Thank you.
All right, who's next?
Ms. Winchester. The last page.
Please see.
All right. Mr. Leslie Roy Winchester.
Yes, sir.
Okay, this is a restitution issue.
Yes, Your Honor. And we've come to an agreement. It's $195,400.
$195,400.
Yes, Your Honor.
And how is he to pay this restitution?
You know, he's serving
He's
his
serving
TDOC sentence, so.
How long is his sentence?
12 years.
I don't remember. 12 years.
All right, I'll enter restitution of $195,400 and manner of payment of that restitution will just be left open.
Kind of the victim's involvement spoken to in there where likelihood of garnering any restitution or lien.
I've got it, but.
Well, another option is to convert it to a civil judgment at some point.
Yes.
And the way they have, if he ever gets a job or ever owns anything, until they satisfies that, they can seize it under execution. Mr. Hooper or Mr. Sensing, you have all of the rest of these folks, so we'll.
Brian Miles.
You want to read this, Your Honor? I had to handwrite it, just so you know what it says. My chicken scratch is not very good.
All right, Mr. Miles is going to be entering a plea of no contest to felony theft and would receive a sentence of 4 years Tennessee Department of Corrections, suspended to probation after, and have no contact with Eddie Rochelle or the Rochelle family, and Rochelle's bar none.
That's his business, Your Honor.
All right. And he would get pre-sentence jail credits from July 30th of 2024 until today. Mr. Miles, raise your right hand. Let's place you on the road.
You solemnly swear or affirm that the testimony I give in this case should be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Brian Fletcher Miles.
Mr. Miles, you're here today charged with theft of property, and it's been indicated you want to enter a plea of no contest. You've heard me explain. A no contest or nolo contendere plea means that you understand what the state's evidence is. You're not going to admit you did anything wrong, but you choose not to deny it or contest it, and the state will then give me their facts, and I will use those facts to find you guilty according to this agreement. Do you understand that?
Yes, sir.
You understand, however, that you can plead not guilty and have a speedy and public trial by jury in this court. You understand that if you went to trial, you would have the right to have a lawyer and to have one appointed for you if you could not afford one of your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. Do you understand, excuse me, that at trial you and Mr. Hooper could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that at trial you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal whatever the conviction and whatever the sentence was to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I will do is to prove what your lawyers worked out.
Yes, sir.
But that's going to result in a felony conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest and give up your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Is your Do you understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are guilty of these charges? You know, I want you to listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, on July the 30th, 2024, Tennessee Highway Patrol Officer Trooper Thomas Wright stopped a black Dodge Durango doing 78 and 55. It was driven by Mr. Miles. Investigation showed that the vehicle was registered to Edward Rochelle. Asked Mr. Miles about the vehicle. He said it belonged to his sister. On further investigation, they reached out to Mr. Rochelle, and he stated that the vehicle was his wife's, and it was at his restaurant out in the Buffalo area of Humphreys County, close to I-40 at his restaurant. Keys were in it, and they had seen Mr. Miles out in the area, but they did not realize the car was missing until they called. So they called.
Right. I'm not asking that you agree with this fact, but do you understand that's what the state's evidence would be at trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
I feel like Mr. Hooper's done a good job of representing you competently.
Yes, sir.
Mr. Hooper, do you know of any reason he should not enter this plea?
No, Your Honor.
Anything further from the state?
That's Your Honor.
And Brian Miles in docket number 15001, upon your plea of no contest to count to felony theft, I find you guilty, sentence you to 4 years, Tennessee Department of Corrections, or that be suspended on time served probation. You'd have no contact with Eddie Rochelle or the Rochelle family or the bar none, Rochelle's bar none. Pre-sentence jail credits from July 30th until today. Thank you.
Oh, I did.
Yes, Mr. Bradley, page 2. I think his name is John Bradley.
All right, I've been handed a document indicating that Mr. Bradley in docket number 14782 is going to enter a plea of no contest to an amended charge of domestic assault, receive a sentence of 11 months and 29 days to serve concurrently with the next case. And that docket number 14783 is dismissed. 14900 would be sexual exploitation of a minor, a Class A felony, would be amended to a Class B felony, and he would receive a sentence of 9 years, Tennessee Department of Corrections, to serve at 100%. He would be on the sex offender registry for life. Sex offender treatment would be required and court costs. Count 2, he would receive a sentence of 6 years, Tennessee Department of Corrections at 100% release eligibility. That would also be consecutive to count 1, cost of sex offender registry for life, sex offender treatment. All right, raise your right hand, Mr. Bradley. Let's place you under oath.
Do you solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
State your full name for the record. Mr. Bradley, you've heard me go over what the agreement is, but have you seen or been shown a copy of the charges against you and gone over it with Mr. Hooper, and you feel like you understand what the facts are against you, the evidence the state would have, as well as any possible defenses you might have? Well, it's indicated you want to enter a plea of no contest. You've heard me explain over and over. That means that you're not going to admit you did anything wrong, but you're not going to deny it or contest it. And the state's then going to tell me what their evidence would be at trial, and that evidence will be used to find you guilty according to this agreement. Do you understand?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that at trial you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Sir.
You understand that if, and we've done that, of course, with a public defender. Do you understand that at trial you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering a plea of no contest, you're waiving or giving up your right to a trial and to an appeal. All I'm going to do is to approve what your lawyers worked out. Now, that's going to result in a couple of felony convictions and one misdemeanor conviction that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. Do you understand that? One of those convictions is going to be for domestic assault, and I need to make sure that you understand this. Anyone who is convicted, by law, I'm required to notify you that if you have been found guilty of domestic assault, it will be a federal offense or a state offense for any person convicted of domestic assault offense to possess or purchase a firearm. This is a lifelong prohibition. From the moment of conviction for a domestic violence offense, you will never again be able to lawfully possess or buy a firearm of any kind. Of course, you're going to have felony convictions as well, but I'm going to have you sign this document also, if you'll have him sign that, please. I'm assuming Mr. Bradley is not in possession of any firearms because he's in custody. I'm not going to have him fill this form out since he's already in prison. And the other aspect I would make sure that you understand is that these two felony convictions are going to be served consecutively to one another, and they're going to require you to serve 100% of those sentences. You understand that? All right. You understand everything I've explained to you so far? Do you wish to plead no contest today according to this agreement and waive your right to a trial and to an appeal? Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied that there is a factual basis for it and that you are in fact guilty of these charges. And I want you to listen as the state tells me what their evidence would be if you went to trial.
Your Honor, in 2022, the Humphreys County Sheriff's Office was investigating Mr. Bradley on several other charges, including sales of narcotics and aggravated domestic assault. And during that investigation, Mr. Bradley was arrested and taken into custody and had a cell phone. During further investigation of that, and looking at the phone through a search warrant for narcotics, child pornography was found. Search warrant was obtained. The cellular telephone was taken as evidence. Obtained without the password, the phone could not be accessed. It was returned to evidence. They were able to obtain the password through further investigation. In February of 2023, Detective Kimbrough of the Dixon County Sheriff's Office was able to forensically evaluate the phone and associated it based on accounts that were downloaded on the phone and other information on the phone that it was with Mr. Bradley. A warrant was obtained again for the phone after this length of period of time to search for child pornography. Detective Kimbrough examined the phone and found more than 1,000 videos or photos of child pornography, covered 125 of the most aggravated of those. And there was also messages between Mr. Bradley and others where he had purchased and uploaded videos and images paying with his credit card. And that would have been in docket number 14900, docket number 14782. Mr. Bradley was charged with aggravated assault. This on December the 7th, 2022. Mr. Bradley and his girlfriend at the time, Tiffany Estep, were involved in a domestic altercation at 113 Oak Ridge Drive here in Humphreys County, Tennessee, in Waverly. Estep advised that Mr. Bradley had been gone for a few days and she was using Bradley's vehicle. Estep advised that they'd been at the residence to swap vehicles with Bradley. He gave him money he'd been asking for it. They got into an altercation, at which point he placed his hands around her neck, pushed her over the center console of the vehicle. He said she kicked Bradley next to the vehicle to get away from him. Said she grabbed her phone, at which point she and Bradley began struggling over it. He advised Bradley forcefully pushed her away from her, threw it across the yard, threw the phone across the yard. Followed her to the carport area, placed his arms around her neck in a choke style manner, began squeezing her to the point she could not breathe. Thus, he was charged with aggravated assault.
He's pleading to a domestic as well.
Domestic, yes, sir.
Mr. Bradley, I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if this case went to trial.
Yes, sir.
You still wish to plead no contest according to this agreement? Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Hooper's done a good job of representing you competently.
Yes.
Mr. Hooper, you know of any reason you should not enter this plea?
No, sir.
Anything further from the state?
No, sir.
All right. Then John Scott Bradley, in docket number 14782, upon your plea of no contest to to the single count of amended charge of domestic assault, and find you guilty, sentence you to 11 months and 29 days in the county jail to serve. That will be served concurrently with the other case. Count one is your order to pay the court costs. In docket number 14783, upon your plea of no, that one is dismissed as a part of this agreement. In docket number 14900, upon your plea of no contest to count one, I find you guilty, sentence you to 9 years in Tennessee Department of Corrections to serve 100%. You're also required to pay the court costs. You'll be placed on the sex offender registry for the remainder of your life, as well as undergo any sex offender treatment that might be required. You order to pay the court costs. Count two, you're found guilty, sentenced to 6 years in the Tennessee Department of Corrections to serve at 100%. That will be served consecutively to count one for an effective 15 years to serve. Court costs, and you're also, again, on the sex offender registry for life and required to undergo the sex offender treatment. And the other counts are dismissed as a part of this agreement, which are multiple. That's the judgment of the court. Thank you.
Thank you, Your Honor.
Thank you.
Chris McNair. Come back to me, please.
Do what?
Mr. McNair pled earlier this morning by Zoom.
Yes.
I've spoken to the district attorney, and we would like to change part of that plea agreement, and I've talked to my client to make it a little smoother.
So this is a do-over?
No, we're not gonna have to do it over. We're just asking the court, instead of it being just for him to serve 2 years, TDOC concurrent to his Hardin County case.
Instead of two, suspended after one.
Right.
Day for day, just flat two.
Yes.
Because he's got a 4 out of Hardin County, so we're gonna write it concurrent to. So what happened, Judge, was when we first made this offer, I was unaware of, and so was Mr. Hooper, we were unaware of a Hardin County case. So in making that offer and then investigating this, I reached out to Hardin County, found out he had that 4-year sentence, reached out to them about his VOP, about what was likely to happen. And they said he's probably going to get 4 years to serve if he was convicted here. I'd already made that offer. I think the confusion was Mr. Hooper just took my offer.
So what are we changing?
We're changing it to 2 years to serve instead of 2 suspended after 1 year day for day. He's just going to go do 2.
Mr. McNair, you raise your right hand. Let's place you under oath.
He's hard of hearing, Your Honor.
Death in 1 year.
All right. We're good.
Death in 1 year.
All right, I understand. Raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Mr. McNair, you've been brought over this morning, even though we entered a plea this morning, because they want to change it to instead of having 2 year sentence suspended after you serve 1 year day for day, they're going to give you 2 years to serve, and then that's concurrent with your Hardin County case. And it sounds like that may be to your advantage. So is that what you understand what we're doing?
Yes.
Are you in agreement with that change?
Yes.
All right, then I will make that change on the record.
Thank you. Last one's Mr. Simpson.
Mr. Simpson, we have.
Yes, Judge.
Beaver.
Yes, that'll be Matthew Seaver on page 22 of the court's docket, 14985.
What's the last name?
Seaver, S-E-I-V-E-R.
Okay, thank you.
And I can have so Mr., and I'm passing up a plea petition that's been executed. Mr. Seaver in 14985 would be entering a no contest plea to possession of methamphetamine for distribution, for which he would receive 8 years suspended on time served to probation. He would be assessed a $2,500 fine and court costs. As a condition of his probation, he would have to complete an alcohol and drug assessment and follow any recommendations. And he must also pass all drug screens with zero tolerance for any failed screens. Counts 2 and 3 would be dismissed in settlement. He would be sentenced as a standard range 1 offender, and he would receive jail credits from 12/17 of 23 and then from 11/1/24 to present. And although it's not reflected on the plea petition, I spoke with General McLeod. I guess he's serving currently a VOP sentence, or he's flat in the VOP, and he's reinstated back to probation. So we would just run this concurrently to that.
All right, so we're going to do this 8 years suspended on time served, and then he'll be suspended to probation, correct?
Correct.
Mr. Seaver, raise your right hand. Let's place you under
You
oath.
solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your full name for the record.
Matthew Ron Seaver.
Mr. Seaver, you're here today charged with a drug offense, I believe, if I understand correctly, possession of methamphetamine. 3-count indictment, but have you seen or been shown a copy of those charges and talked them over with Mr. Sensing? You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
I have.
Well, it's indicated you want to enter a plea of no contest. You've heard me explain repeatedly that means you're not going to admit you did anything wrong, but you're not going to deny it. And the state will then tell me what their evidence would be if this case went to trial, and that evidence will be used by me to find you guilty according to this agreement.
I do.
Do you understand that you have the right to plead not guilty and to have a speedy and public trial by jury in this court?
I do.
You understand if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford one.
I do.
And we've done that with a public defender, of course. Do you understand at trial you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything? You understand that if you went to trial, you and Mr. Sensing could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand at trial you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out.
Yes, sir.
That will result in a felony conviction. It's going to be on your record in the future to make more severe the punishment you will have if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest to this charge according to this agreement and give up your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest, is that a voluntary decision on your part?
It is.
Anybody forcing you to do this against your will?
Fair enough.
You understand that I cannot accept this plea unless I'm satisfied there was a factual basis for it and that you are in fact guilty of these charges.
Yes.
I want you to listen as the state tells me, step aside and let the state tell me what their evidence would be if this case went to trial.
Yes, Judge. If this case had gone to trial, the state would expect to be able to show that back on December the 7th of 2023, Officer Chris Browning of the Waverly Police Department stopped a vehicle traveling south on Sycamore Avenue here in Humphreys County, made contact with 2 individuals, one of which was Mr. Seaver. He could smell marijuana coming from the vehicle, so he conducted a search and found at least 1 ounce of crystal meth on Mr. Seaver. Mr. Seaver had a needle, didn't have any scales because he told the officer that he had recently broken them. Also told the officer that he is a drug dealer. He makes his money by selling meth.
Mr. Seaver, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? You still wish to plead no contest according to this agreement? Are you satisfied with your attorney's services? I feel like Mr. Sensing's done a good job of representing you competently. Mr. Sensing, do you know of any reason you should not enter this plea?
I do not.
Anything further from the state? Then Matthew Seaver, in docket number 14985, upon your plea of no contest to count 1, I find you guilty, sentence you to 8 years, Tennessee Department of Corrections. That will be suspended on time served to probation. You're ordered to pay a $2,500 fine and court costs. You must complete an alcohol and drug assessment and follow any treatment recommendation. And you must pass all drug screens you're given with a zero tolerance for any failed screens. That means one failed drug screens, you're going to go to prison. Do you understand that? All right. That's the judgment of the court. Thank you.
Thank you, sir. Yes, sir. Sorry. How are you doing?
Other than things I need to sign, is there anything else y'all need to address?
I have two things, Your Honor.
It was a rhetorical question.
Well, one on Mr. Bradley's plea, he had asked me, did he get jail credits? They are, just for the record, they are listed. I told him that he did. On Julie Stewart, Your Honor, that was one that you had
A show call.
A show calls issue because it was a restitution issue. We spoke to her over the lunch break. She thought she had court next week. I was going to ask the court to recall that and have her come on the 25th. We gave her that court date.
All right. That's fine. Recall, it's just going to be a show cause. I wasn't issuing an arrest warrant.
Sure.
Recall the show cause and just set it for the February 25th date.
And then one that we have not covered on the doc day is Carlos Leon. He's on page 19, Your Honor. We had second called his case for me to talk to the general over break. I'm not sure why he's not in the courtroom, but I've not seen him come back from lunch. I've had communication with him. He may have just been confused, but we are going to set him on the 25th if the court will allow us. I think we can work that out.
Because I think we do have a settlement. We just need to talk to one of the victims about a possible minor amount of restitution before we settle.
And I'll make sure my client knows to be here, Judge.
All right, 25th February.
Thank you, Judge.
Thank you, Your Honor.
Sensing you have anything else?
I do not, sir.
All right, then we